Good morning, good morning, good morning. It's Tuesday. It's an early morning in court in South Carolina. Court has not yet begun. I have coffee. I'm sure there will be cursey words. Today, we are here for the pre-hearing conference. I expect this is where the judge will hear argument regarding Alec Murdaugh's motion for new trial. I'm going to give a whole rundown of that. We have a clean court feed courtesy of Luna Shark Media, who hosts the Murdaugh Murders podcast, now known as True Sunlight and Cup of Justice. So we are using their feed. Yay, independent media working together. I'm going to give you more information on where you can find their chats and stuff throughout the day. And we will be joining their group a little bit later when court is on break and what have you. So I'm really excited that we are able to work with them to access their court feeds in court, because as independent media, being able to access things like this can take some time, and working together makes it easier. So a huge, huge thank you to Luna Shark. And what's amazing is they're like streaming it through StreamYard. I'm streaming it through StreamYard. These technological advances have made it so much easier for us to literally run media companies. I'm so excited. So let's give a quick road so far for today after we roll the intro. While I'm rolling the intro, let me know where you're coming in from, what you're drinking. I have a vat of coffee. This was my first Stanley mug ever, the Stanley Starbucks Club. I have a vat of coffee. That's what we're doing today. And we got to hydrate as we caffeinate. So we've got that too. All right, let's go. Deb Jackson, I did know that I am Rob's dog's lawyer because Leo, my client, has been defamed and set up. So absolutely. But it's kind of for trade because Rob is Fred's lawyer. George doesn't really need a lawyer. Rob is Fred's lawyer. So let me know where you're coming in from, what you're drinking. For all of you that are snowed in today, and so you get to hang out in court with me, I think that's the best. We'll see how snowed I am in today and if I make my flight this evening at like 6 p.m. Fingers crossed. Let's get into it before this hearing gets underway and do a road so far.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
The intro is we're here to talk about facts, but today there's going, I'm warning you, I'm sure there will be a bit of nonsense. If we have time, we'll go over the defense new motion. But let's do a quick road so far for those of you that may or may not be newer to the Murdaugh case. If you didn't watch the Murdaugh case here on my channel, this might be a newer case for you. That's fine. Let's ciao Bella. I know. We're just gonna cross our fingers and say lovey. Like whatever happens today happens. We're just gonna do it. For those asking who the lady is with Murdaugh, this is one of the defense attorneys. We can back up a little bit on this feed and see that he's sitting there with his attorneys and stuff. So this is part of his legal team, all sitting at the table with him. And now we're gonna zoom back to live feed. They're probably going over the motions they filed and stuff. Here's what's happening today. Let's do a road so far to South Carolina. Alec Murdaugh was convicted of murder of his wife, Maggie, and his son, Paul, back in March of 2023. We watched the 3-week trial that ballooned into a 6-week trial because it was a 3-hour tour. Then we had all the financial crimes left: theft from clients, defrauding banks, defrauding legal partners, tax fraud from the state level. We haven't seen the feds on that yet. There's also federal financial crimes. There's also the allegation that he staged a suicide for hire insurance scam. That one is still pending, the roadside incident. All of those he recently pled to for 27 years state prison. The day after his murder conviction, with the swiftness I have never seen. Everybody's like, can we sentence tonight? No, tomorrow morning? Sure. We'll be back in the morning. And he was sentenced to 2 life sentences literally the next morning. It was wild. Since then, his defense attorneys or his defense team filed a notice of motion for appeal. But because this was a 6-week trial, they were still waiting on the transcripts for the appeal. Appeals, as you know, we've gone over a few, are heavily rooted in the transcripts of the trial, right? Because what you're appealing is shit that happened during the trial. So you need those transcripts. So they were still waiting on the final and official transcripts. While that happened, the defense made a motion to stay the appeal, meaning they wanted to pause, put a pin in it. They're going to circle back later to stay the appeal and then file a new motion for new trial. Normally, these new trial motions are heard immediately after trial. Your Honor, we'd like a motion for new trial and a motion for judgment notwithstanding the verdict. And the judge is always like, I'll listen to you, but no. And then it goes up to appeal. You can only bring another appeal if you have new evidence. And the defense has argued that their new evidence is that the clerk of court, Becky Hill, called on this channel Courthouse Becky, messed with the jury. There are allegations that the elected official, the clerk of court, spoke to the jurors about the substance of the case. Now, you're allowed to speak for the jurors as a court officer about, hey, we're coming in tomorrow morning at 10 instead of 9:30. Hey, we need to put in an order for lunch. Hey, you can park over in this lot. Hey, do you need a note for your job? About procedural things, non-substantive things. The allegation here is that Courthouse Becky spoke to jurors about substantive things. The next step is whether or not the court will grant a hearing. The prosecution, even in their motion, said, we might need a hearing about the thing. Like, we might need a hearing about the thing. The next step should be, is there going to be a hearing where they interview jurors? If you've watched the Taking Care of Maya case or my coverage of the Maxwell case, the court first had a hearing to decide if there would be a hearing. This court seemed to have skipped that step. In the defense's most recent motion, it said, since the court has indicated that a hearing is happening at the end of this month, this hearing today should be to decide the procedure. Normally, you would get a hearing to decide if there's a hearing. It seems that a hearing is going to happen. Has there been a ruling on paper? No. Have I seen a ruling made in court? No. Does it still say that there is a hearing coming at the end of the month? Yes. So I'm going with there's going to be a hearing. And this is all procedural over what witnesses will be called. Will they be interviewing jurors? Will those jurors be interviewed in public view on the witness stand in open court, or will they be interviewed back in chambers? Will the judge be conducting the questioning? Will the lawyers be conducting the questioning? Will Courthouse Becky take the stand? Will she be allowed to plead the fifth? Is Judge Newman going to be called to the stand? Will that be in chambers or in public? What procedure is going to happen? They've set aside 3 days at a minimum, like 5 days maximum for this hearing. If you watched the Taking Care of Maya case, one of the jurors was brought in to be questioned. The court did the questioning. The juror was questioned for like maybe 5 minutes. I'm very ADHD. I don't know how long time goes. A shorter period of time, and then dismissed the juror, came back in, asked the lawyers if they had any more questions, brought the juror back in, asked a few more questions, and dismissed the juror. The whole thing was like maybe 10 minutes, maybe 15. It was very limited in speaking to that juror. In this case, there are going to be more witnesses than that. So I think, based on all the cases I've covered, both federal and state, that most of the law anticipates that if jurors are going to be questioned, the jurors. I didn't say that well, like Judge Newman, because I can't, but kind of. If the jurors are to be questioned, I think it is only proper that the judge does those questioning. So I think we will see the judge take on the questioning. I will be very surprised if they let the attorneys question the jurors. Now, when it comes to Courthouse Becky, that's a little bit of maybe a different situation. But when it comes to the jurors, I think it's only proper that the court does the questioning. This is a great question from the chat. Roxy said, if it gets a new trial, it'll go to a new judge. I think if it gets a new trial, it might stay in front of this judge, which is Justice Toal, called Justice, not Judge, because she is a former member of the state Supreme Court. I will do my best to remember. I might use the two synonymously because justice and judge is justice and judge, but it will not be Judge Newman. So there's that. I will be very interested to see what happens, but I think the entirety of what they're doing here today is going to be lining out the ground rules. What does this hearing look like? And then at the hearing, they will decide, after the evidentiary part, whether or not Alec Murdaugh is entitled to a new trial. There is also some disagreement between the lawyers with regard to the standard, like what has to happen. And that will probably be decided today, though I imagine the judge, because this is a former appellate judge, this is all lawyer speculation. Look, don't say it's happening because I said it. This is lawyer speculation. Lawyer speculation. It is my legal speculation that after today's hearing, the judge will at some point very soon issue a written warning, order for this. I don't know if the judge will rule from the bench. I think that the judge will likely take this under submission and write it down. So let's see. Dana asked, Ms. Becky can't be fired, right? Because she was elected. She's elected, and it seems that there's not a real good procedure to recall her. So I don't know what they're going to do in South Carolina except pass laws that allow people to be recalled. I don't think she can be recalled. And I also think she's going to stay on until something more formal happens, because we've heard that, well, we know there's the investigation into her son for the wiretapping. He was an IT director in the county. We know that she's admitted to plagiarism of her book that's in evidence here in the office somewhere. We know that there's a lot else going on. So I imagine that she will do everything she can to keep her job until she can actually no longer keep her job, which might be when she comes up for reelection. When is that? I don't know. When she's up for reelection, but no, she can't be fired. I saw a number of you ask in the chat, does that mean she's the clerk of court for this proceeding? Great question. Absolutely not. When this case was reassigned from Judge Newman, it was reassigned up to the state Supreme Court, and they shuffled a judge. They pulled Justice Toal, who is a retired judge. So they pulled in Justice Toal to cover these hearings. When that was done, instead of filing all of the documents through Colleton County, they ordered that everything would be filed through the Supreme Court. So the Supreme Court is handling all of the documents. What they asked for, or what they said in the order, was that because of these allegations against the clerk of courthouse Becky, it was, unseemly is my summary of it, but it was inappropriate to have her in charge of all the documents for this case. So everything's being filed through the Supreme Court and being heard by that judge. So it's going to be very, very interesting. Nicole said, I think this is in Richland County today. It doesn't, where the court is sitting today, like the physical location of the court, this is still a Colleton County case. So everything would have been filed in Colleton County with Courthouse Becky, the Colleton County Clerk of Court. Because of the Supreme Court ruling, everything's being filed with the Supreme Court, and then they are sitting where either it is most convenient to transport Alec, where it's most convenient to the judge, or what have you. But they are sitting differently, but they are sitting with a jurisdictional exception to allow them to sit in another court instead of sitting in Colleton, if that makes sense. Is YouTube having problems? My chat keeps shutting down. I have no idea, but we can reach out and ask. Emily's Life on Wheels said, what kind of qualifications do you need to be a clerk of court? Like, what would somebody need to know to run, how to run against her? I don't know what they set up in South Carolina for the standards for elected officials, but a lot of time elected officials don't have to have any particular background. I imagine a strong background in administration would help, and maybe one in courthouse administration would help, but you never know. The way I could have started streaming at 9 a.m. and it would have all been fine. Laura J said, not sure if this has been answered, but is Judge Newman officially retired yet? I don't know if he's officially retired, but I know he's reaching the mandatory retirement age. Vicky asked, will Alec Murdaugh go to federal prison? I think Alec Murdaugh would like to go to federal prison. He has not been sentenced on his federal cases. All of his sentences are state cases, so the state will fight to keep him in the state cases. I think Alec Murdaugh and his lawyers all feel that it might be better for him to be in federal custody. We'll see. We'll see. The Bureau of Prisons will fight about that, but because he's been sentenced on all the state cases, I imagine without getting some kind of leave, he will serve all of his state sentences in state prison first. So, got ice here in Chattanooga, so it's great to have something to keep me entertained. I mean, we are snowed in Nashville. EDB, what's on your bingo card for today? Lawyers saying this will be brief and then being anything but fucking brief. So, Joni Nick says, Justice Toal has been quoted in filings. Isn't that a conflict? No. Judges, especially in smaller jurisdictions, will often quote themselves because cases that they presided over created law. And with Justice Toal being a former Supreme Court justice, I'm not surprised by that at all, because she would have been ruling at the top or the highest court in the state on issues similar to this. It might give the attorneys a better idea of which way she might be inclined to rule, because she's already considered similar issues. But judges don't pre-rule a case. But no, it's not a conflict that she's been quoted in the filings. So we lost our feed for just a second. I'm sure it will be back in just a minute. So with all of that, hopefully it will be back in just a minute. There we go. We are now back in court. So, and it looks like more attorneys are coming in. I imagine these lawyers were all back in chambers because they're all walking back in from the back. This courtroom has a lot more space in it than other courtrooms that we have seen, which might be the reason they chose this particular courtroom. That gallery is chock full of lawyers. There's our favorite defense attorney, Barber. I will move my big head if we need to. But we see all of Alec Murdaugh's defense team, Poot, Jim, Barber et al. Creighton and the whole crew is going to be there too. I haven't seen Creighton yet, but they will all be there. I imagine that all the lawyers were back in chambers chatting with the judge about the hearing today and what's going to happen. That might speed run this hearing because they've all chatted about it in chambers before. So let's see. Question, is Judge Newman still overseeing this case? No, Justice Toal is. Let's see. Sarah, I understand this feeling. I'm going to just offer an alternative perspective, if I may. Sarah said, I wish Alec Murdaugh would just take his punishment. He did plead to 27 years on the financial crimes. So I understand that feeling. However, if they do a hearing and Courthouse Becky did what she's accused of doing, they have to have a new trial. You can't substantively talk to jurors about not believing a defendant and not have a new trial. It's a miscarriage of justice. I rather have them get it right than do it fast. And I think if Courthouse Becky didn't do what they're accusing her of doing, then we've got problems about these attorneys maybe bringing things to the court that they didn't have basis for. But we've seen the jurors' affidavits where they said that the court said things to him. And if the clerk said things to the jurors substantively about the case, that is a huge problem. And that is a huge problem that could have easily been avoided if the clerk of court didn't say anything to the jurors. And I don't know if the clerk of, like, how many books can screw up your life, but where did my book go? I don't know where I put it. It's in the office somewhere. But look, every time I want to hold up that book, I'm just going to hold up Mandy Matney's book instead and be like, read this one. When I need a book prop, we're just going to hold up Mandy's book. Maybe it'll annoy Poot. It's like the power of Christ compels you. This book, written by the clerk of court, which I begin to believe, I've always believed was inappropriate because it's an elected official using their elected position to have a vantage point at which to write a book. It does not sit well with me. I don't think it's ethically proper. That's my opinion. I hate it the most. For those asking why it's blurry, because streaming out of South Carolina can be difficult. to get signal to stream out. So yes, it's a little bit blurry. Don't worry. I'm sure it will resolve. We'll refresh the feed. And again, what's really important for our matters is to be able to hear everybody. So that's the most important part for us. It looks like the lawyers went back and then came back again. All right, let's just refresh. So we now have some of the prosecutors coming back out to court. This is everybody's standing, which means the Justice Toal is probably coming out in just a minute. And hopefully we'll get audio in just a minute. So with all of that, I imagine we're going to get the judge out here in just a second. With all of that, if the clerk did what they're accused of, it's a huge problem for this conviction. And I think that everyone has the right to a fair trial. So for those of you that are like, I'm good with Alec being blurry, I get it. They are uncuffing him for the hearing. So that's what's happening at the moment. But look, it needs to be. I don't know what South Carolina is using, but it's hard. Streaming out from a news van, depending on the weather, can be a challenge. So Sunshine Cheryl said only if it affected the verdict. There are going to be a conversation today about whether or not there is 2 prongs to this analysis at the hearing next week or 1 prong. Can Courthouse Becky be responsible for new trial costs if found to have interfered? She probably has some type of immunity because of her job. So she probably has some type of immunity. So it would be very, very unusual that she would be required to pay. Could the county maybe sue her? I don't know. Would others be uncuffed for a hearing like this? Possibly, especially because he has a waist chain. And it looks like what they did is loosen his cuffs to the waist chain and not uncuff him entirely.
Thank you.
I missed what the judge said, so we're gonna back up.
Allow me to use of both of the tanks, please. We are. Thank you.
I still couldn't hear what the court said. So, this is the difference. It doesn't matter if it affected the verdict, can't talk to jurors. That is the argument here. The defense is arguing if the clerk of court talked to the jurors about anything substantive, not scheduling and stuff, then new trial de facto, do not pass go. The prosecution is arguing even if she did talk to jurors and even if it might have been substantive, you still have to prove it impacted the verdict. So those are the 2 legal standards that are being argued. What actually has to be proven? And we see that Alec is uncuffed so he can write in court. He's never had an outburst in court. He's never had a problem in court. I think it would be unlikely that he would. So I don't think there's any hesitancy about having his hands uncuffed when he still has waist and leg restraints. So, thank you, Jennifer. So, is Becky present today? Probably not.
Matter of state against Richard Alexander Murdaugh. It's case number.
This is Justice Toal.
GS 15-00592 through 00595.
There's multiple indictments.
Murdaugh was indicted for the murder of his wife, Margaret Branstetter Murdaugh, and his son, Paul Bennett Murdaugh, and related weapons charges.
Yep.
His trial began on January the 23rd, 2023.
Almost a year ago, friends.
The judge was Clifton Newman. After 6 weeks of trial, on the evening of March 2nd, 2023, the jury returned a verdict of guilty on all 4
in
indictments.
like 3 hours.
On which the defendant was sentenced on March 2023 to 2 consecutive terms of life imprisonment. Notice of appeals of his convictions and sentences were filed by defendant Murdaugh's attorneys on March the 9th, 2023 with the South Carolina Court of Appeals. The transcript in this very lengthy trial took several months to produce, even in draft form.
We were just talking about that.
Before the attorneys received the final transcript, on September the 5th, 2023, defendant filed with the Court of Appeals a motion to suspend his appeal and for leave to file a motion for a new trial with accompanying affidavits and transcript experts. After further defense and state filings on October the 17th, 2023, Court of Appeals granted Appellant Murdaugh's motion to suspend the appeal and to remand his case to the circuit court to allow defendant Murdaugh to file a motion for a new trial. On October the 17th, 2023, defendant Murdaugh received the final trial transcript and very shortly thereafter filed a motion for new trial in the Colleton County Clerk of Court's office. Subsequently, Judge Clifton Newman recused himself from further proceedings in this matter. On December the 16th, 2023,
We covered that in other coverage. The recusal.
on December the
I
18th,
love
2023,
A Road So
Chief
Far
Justice
with a Southern
Don
drawl.
Mallory signed an order appointing or directing that the Honorable Jean Hafer Toal, retired Chief Justice of South Carolina, be assigned exclusive jurisdiction for the limited purpose of presiding over defendant's motion for a new trial. I promptly contacted counsel in this case and set deadlines for briefing.
Meaning she's not been assigned for the new trial if it happens.
The new trial motions were set to be argued on January the 23rd, 30th, and 31st of 2024. And after several rounds of pretrial briefs having been submitted to me, I also set today's date for a procedural pre-hearing.
The defense has submitted like 3 pretrial briefs at this point.
Before I begin, may I say that we certainly welcome members of the media, and I thank publicly Attorney Jay Bender for agreeing to be the voluntary media coordinator for this matter, as he did for Judge Clifton Newman on the trial of this matter. Cell phones are normally not permitted at all in our courtrooms, but the press has been allowed to bring in certain cell phones and laptops and electronic devices.
Court is not as full as I thought it might be.
The nature of this portion of the proceedings. But if any device rings or sounds to receive a call or to receive an email or a message, that device will be confiscated and the owner will be asked to leave the courtroom. So please now, if you haven't already, check your electronic devices.
Turn off your cell phones. Lawnards, you don't have to. Lawnards, you don't have to turn off your cell phones.
Major topics to be covered today have been addressed by me and discussed with counsel in a short pretrial conference in my chambers. And counsel may have certain things that they will put upon the record as we proceed.
It's a very fancy appellate court.
What should be
Look how long that table is.
The first topic is an evidentiary hearing necessary at all? The state took the position.
State courts aren't as fancy.
That was no. Obviously, the defendant not. I have set an evidentiary hearing because I felt like we had to have some brackets on the time we would spend on this matter. But I've made no conclusive decisions beyond that.
Well, thank you for clarifying. I'm going to pause for a second because that's very helpful. Justice Toal just said that she set the dates for the evidentiary hearing if it's needed, but she has not conclusively made a decision that there will be an evidentiary hearing. I think she's going to do that. Newsflash. I think that's going to happen today, but I appreciate her clarifying that she hasn't made a ruling on that yet. Thank you, Your Honor. We've been so confused.
The arguments the state makes about the procedural posture of this matter. The next topic would be the burden of proof. Who has the burden of proof in this matter?
The defense.
And what must be shown to meet that burden?
That's the big question.
And what must then be shown to contest what has been shown and proved? The third topic is procedural defects.
She's covering a lot today. This is going to be a long hearing.
Contention by the state that this motion is untimely because of what was known before a verdict was rendered accepted in the jury poll. And finally, we need to discuss witnesses, juror witnesses,
The jurors.
Court of Compton County Appeals.
I love it so much.
And other witnesses and exhibits. I note that at least one attorney in the room is an attorney for some of the jurors, and other jurors may
Eric
have
Bland's in the room.
When I get to the portion of this discussion where we talk about specific witnesses, and if I am asked to hear from attorneys for the witnesses, I will at least consider that request.
Oh!
It will be at that time in terms of what has been decided.
I am surprised by that.
I would at least inquire about that. To that end, if you have not already, during the first break, be certain that all of you, the lawyers participating at council table, and any other lawyers that feel they may have some interest in the proceedings that would warrant comment by them, please give your cards or information about your contacts to our court reporter, Ms. Harris.
It's going to be a busy day.
With that, Mr. Harpoon, you're moving party, you may proceed.
Y'all, I see a lot of conversation in the chat. I'm going to pause this real quick before we get to Dick Poot et al. Kathy with a C has clarified that this is Justice Jean Toal. She is a former Chief Justice of the Supreme Court of South Carolina and was the first woman to serve as Chief Justice. So, y'all, Justice Toal is in her 80s, is my understanding. And that is that. Why are there no subtitles? Because this is contemporaneously live and we don't have contemporaneous subtitles. I'm going to go ahead and boost the audio just a little bit on my end, and then we will go from there. Courts are often recorded via potato, but some of that is because of the difficulty in broadcasting it out from remote locations. So you're welcome. I just saw quite a lot in the chat. Look, as a woman with a resonant voice, I am not surprised that people are asking about Justice Toal, but also we are going to just make it clear because she is the first woman Chief Justice of the South Carolina Supreme Court, and respect is due. All right, let's keep going.
Please, of course, Your Honor, you've raised, I assume you want to go in the order in which you just...
I would.
Okay. You raised a number.
She put it in an order because that is the order she would like to go in. When she said today, we need to approach these things, this is what is going to be approached. I'm also going to be keeping tabs of the questions you guys ask and pulling them up when we get a break.
A number of legal issues from whether we've waived, I mean, a number, I forget the order in which you just took them. Mr. Griffin is going to address those in seriatim based on what you said just a moment ago. As to the witnesses and the jurors, I will be handling that portion of the argument today.
Very good. Mr. Griffin, we'll hear from you now.
Yes, thank you, Your Honor. The first issue that you've asked us to address is an evidentiary hearing necessary? And the answer to that question is very straightforward, is yes, under...
I feel like he wants to be like, duh, Your Honor. Just, excuse me, Your Honor. Obviously, we need a hearing. But I'm glad that she clarified that this is not a foregone conclusion and she hasn't ruled yet.
Under established case law in the Supreme Court, the Fourth Circuit, and the South Carolina Supreme Court under Reamer, a Reamer hearing is absolutely necessary where there has been credible evidence presented.
I kind of want a hearing too. I
want
a hearing too.
Third-party contact.
I'm going to put up a poll.
With the jury prior to their deliberations.
Let's see if our polls are working again.
Frankly, whether it goes to the merits or not, a Reamer hearing is absolutely necessary. And we believe that the Court of Appeals decision in this case contemplated a Reamer hearing. And in a Reamer hearing, evidence is presented as to what outside influences, if any, were brought to bear
So
on the jury.
an evidentiary
We had
hearing
our
with witnesses.
motion
Reamer's
for
the
new
case.
trial, submitted affidavits of one deliberating juror, one alternate,
Egg lady juror.
and then another affidavit of a witness to an interview of an alternate, where in all three statements.
Sir, I can hear the hearsay. The other was a sworn affidavit of a witness to a conversation with an alternate juror. Stop it, Jim. Stop it. Stop.
Are consistent, and in that
Stop.
they heard Ms. Hill, the clerk of court, prior to deliberations, and frankly, before the defense put on their case.
I think the deliberating jurors are what matters most.
Not be fooled by the defense. That's what the sworn statements say. And secondly, before Mr. Murdaugh took the stand, Ms. Hill advised one deliberating juror and two alternates at least.
Are Becky Hill and Alec Murdaugh around the same age? Did these two go to high school together? I got questions.
He's going to lie.
They all go to Wade Hampton High School.
So then the question becomes, factually, did those contacts happen? And then, we proceed from there as to what the burden of proof is after that. But the threshold, are we entitled?
Is there a hearing? And then what happens at the hearing?
Thank you, sir.
I think they might be.
Waters to the state.
Creighton.
Thank you, Your Honor. May it please the court.
I'll make this brief.
Your Honor, obviously, you've addressed the issue of whether an evidentiary hearing is necessary. The state certainly understands that. It is incumbent upon us, though, based on the law.
All right, let me see if I can make the feed a little louder. Thanks, chat. Miguelina let me know that y'all were like, can we boost this a little bit? Yes, we can. Let's boost it one more time. And go from there.
To preserve our arguments as to procedural bar, and those are twofold. And the first one, of course, is that a motion for a new trial must be filed within 10 days of the verdict, unless there's after discovered evidence. And I think an initial inquiry that needs to be.
Creighton, I think there's after discovered evidence, but he's going to argue that we need to know when Dick and Jim knew, because Dick and Jim gave some really interesting interviews to the media that indicated they might have known sooner.
Determined is when the defense first learned of these particular allegations in conversations with defense, and they said they're going to give me an answer, that they may have had conversations with juror 785 prior to her being represented, which was only a couple days after trial. So if that is the case and they were aware of these allegations, then we would want to argue to Your Honor and preserve the issue that this is not after discovered evidence and that there's a procedural bar in that regard. Secondly, we made the argument that the affidavits on their face, the only deliberating juror indicated, and that's 630, in that affidavit only said that she voted guilty. She had questions but voted guilty because she felt pressured by other jurors. And of course, the law is crystal clear in multiple cases that sort of internal debate, it's actually in Rule 606B, that's not any sort of misconduct or anything that is a appropriate venue or mechanism in order to attack the verdict. So for that reason, we've argued that their showing in their motion for a new trial is insufficient based on the case law for an evidentiary hearing, because there is on its face no sufficient allegation of prejudice. That being said, of course, we fully understand and expect the evidentiary hearing will go forward, and we'll be happy to address burden of proof after the defense makes their arguments.
Very good.
Look at you, Creighton. You put them all in the court, a different courthouse. You got the stadium seating like it's an appellate court. You got the long benches, and all of a sudden everybody can say shit in 5 minutes. It's incredible. They're definitely not running down the clock on this judge. And I think that means Justice Toal does not have tolerance for yammering. I'm sorry, Your Honor, I yammer.
With respect to, Mr. Griffin, anything in reply?
Becky Hill and Alec Murdaugh were both born in 1968. This makes sense. It was giving these two went to high school together vibes.
Your Honor, it does not appear that the state, takes a position contrary that a Reamer hearing is required. They're arguing that we have sort of waived the right to that hearing. There's no evidence of the record of that. I can assure the court we did not know of this information within 10 days after the trial. And when we learned of it.
Right after the trial, He said in a media interview, I'm pausing to interject. He said in a media interview shortly after the motion to stay the appeal was filed that they were told right after the trial that something's up with the jury to look at what's going on with the jury. So Creighton's arguing they said that they were told right after the trial, so why didn't they file it within 10 days?
We promptly acted.
I like the procedural attack. I think it's
Well, in
proper.
conversations with Mr. Harpootlian and Mr. Griffin.
She didn't tell you to
we're gonna
talk, sir.
actually look into that and look at their paralegal's notes. So I fully rely on and trust the defense to give me a fair answer to that question. And then again, if there's an issue to be raised, we would raise that. We're not conceding anything. We just wanted to preserve our procedural issues.
I don't think we need to go back and forth many times about this. I think I understand.
Sit down, Creighton.
Here's my position on the matter. First of all, I am not conducting a Rimmer hearing. Rimmer is a 1954 decision of the United States Supreme Court.
Oh, she's not talking about the rumors, the nastiness. I couldn't help myself. I'm sorry.
Deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge, State versus Green. And the Green decision specifically says that Rimmer is not the guidance that South Carolina trial judges should look to in conducting hearings on after discovered evidence.
I know this sounds like wah wah wah
And
law.
that says nothing about what the burden of proof should be.
This is the important
I
stuff.
don't intend to say anything thereby, but I do intend to tell you right away that I will be relying on South Carolina's jurisprudence and South Carolina's jurisprudence specifically on what must be proved in a hearing of this nature and who bears the burden of that proof. All right.
So what the court said, I'm going to pause this real quick. I'm going to boost this audio one more time. It is getting better. Reception is a situation deep in the bowels of this courthouse. So bringing out live feed is not always easy, but I appreciate that we have it and the sound is much better. What Justice Toal just told the attorneys is what case law lineage she's going to be relying on, which is very helpful to them in court. So the attorneys that have read all the case law and are familiar with it will know a little bit about which way she's leaning. So I appreciate that. So
That leads to the very next topic that we'll now take up, which is the burden of proof. Mr. Griffin?
Yes, Your Honor.
This is the most important part
As we cited in our.
because I think a hearing's happening.
We believe.
Oh, my coffee's so good.
The controlling case in this instance, based on.
Oh, I didn't put court back up. Y'all are watching me drink my coffee. I'm sorry.
Here at Clerk Court, having
My
communication
bad.
with the jury about the
I was
substance
listening.
or the merits of the case, that
Apologies.
the standard to be applied is not green, because green, Judge Kittredge says that the contact by the bailiff was about a procedural issue, not about the merits of the case. Here, we're dealing specifically with the merits of the case, and the Court of Appeals decision in State v. Cameron, we believe, is the controlling standard. And in State v. Cameron, and that was decided in 1993.
Coffee hasn't kicked in yet.
And the court says, in citing Holmes v. United States, which is a Fourth Circuit opinion, says in this case, there was a private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Now, we strongly believe that is the standard, is the question of
Could not have affected the verdict. The defense is arguing whether or not there's the possibility. And the clerk of court saying, don't listen to anything the defendant says, could impact the verdict. They're arguing over what has to be proven to give Alec a new trial, this is the most consequential part of the hearing, because the standard that has to be proven is going to determine this case, right? So this argument is the most consequential. I think the judge is going to grant a hearing. But what happens at the hearing, this part matters the most. And he's arguing, if you show that any substantive conversation happened with the jurors that could impact their verdict, like talking about whether or not to believe Alec, then that's it. You don't have to ask the jurors, did it impact your verdict? Because what are jurors going to say when they're on the stand in front of the judge? Like, did it change your verdict? They're going to be like, no, I don't want to be in trouble. And that's what's going on here.
Was the subject matter of the communication harmless, and that it could not have affected the verdict? And that's our position on the standard. Your Honor, if Your Honor looks to a different standard, we believe that State v. Green, the measure of State v. Green, you can't look just at Justice Kittredge's opinion.
State v. Green is what she said she was doing.
The Court of Appeals decision. And the Court of Appeals decision absolutely applied the Reamer standard of the burden of production is on the defendant, but when the defendant produces evidence of a substantive communication to the jury.
The court said she was looking at State v. Green, and the defense is arguing that's not the right case.
Then there's a presumption of bias, and that the state then has to overcome that presumption,
Which shifts the burden.
Strong, clear, and convincing evidence that it was harmless.
It's a good argument. I don't think it's going to go very far, though.
The Court of Appeals applied to State v. Green. And in State v. Green, the Court of Appeals says that this is the standard of the Fourth Circuit, and we follow the Fourth Circuit law in this area. Now, Justice Kittredge says that the communication by the bailiff, which essentially said, if you're deadlocked, which they never were and never became deadlocked, then the judge may ask you to stay locked. I mean, that was the communication by the bailiff in Green, and Justice Kittredge says that did not go to the merits of the case. Justice Kittredge didn't throw out the Reamer presumption standard in State v. Green, Your Honor. And it's important, the Court of Appeals decision looking to the Fourth Circuit, because, as Your Honor knows, this case, and I would encourage the court to look at the Holmes decision out of the Fourth Circuit, which we cite, which applies Reamer. It applied Reamer in a habeas corpus case when they said Reamer is the clearly established law in the Fourth Circuit. And it vacated a death penalty conviction out of North Carolina because the North Carolina courts did not follow Reamer. And so the Court of Appeals decision in Green.
Lawnards, help me. I thought we were in South Carolina. Did I go to the wrong state again? Am I in Charlotte and not Charleston? Why is this man arguing North Carolina jurisprudence when this judge clearly got on the bench and said, I am considering only South Carolina jurisprudence? I thought we were in South Carolina. That is what Justice Toal said. Jim, stop it. Did we go to the wrong state? No, he's arguing North Carolina jurisprudence because it's the case law that suits their side best. And Justice Toal has already said that the Green case is what she wants to consider, not the Reamer case, which he is arguing now. So we can't use them synonymously. Jim.
Says we look to Reamer.
Yes, they are in the same circuit. They are in the same circuit.
We're not going to apply the Reamer presumption.
She wants
because it didn't go to the merits.
Green, the South Carolina case, not Reamer, the district case.
Presented through proffer on the affidavits.
But yes.
Something that goes to the heart of the merits. It's the defense.
But also it's an inside joke.
The credibility of the defendant's testimony. And so we do have the burden of production, but we do believe that the standard in
the burden
Cameron
shifts.
Is we just have to show that the subject matter of the communication, that it was material to the case, and that then the burden shifts to the defendant to prove that it was harmless. The burden shifts to the state to prove it was harmless.
Thank you, sir.
That's what we believe the standard is.
Mr. Waters?
Sorry, Carl.
Waters is going to argue the Green case, I would imagine.
Your Honor, and I'm going to walk through some of the cases in South Carolina today.
My learned colleague has talked to you all about our circuit jurisdiction from North Carolina, but Your Honor, I am going to walk you through South Carolina jurisprudence, just like you asked for. Get it, Creighton, let's go.
Address this issue, but as Your Honor is aware, of course, when we deal with these issues, we have two types. We have internal misconduct, and our courts have been reluctant, Rule 606 says this as well, to delve into that unless there are concerns of fundamental fairness like racism and things like that. And then there's external allegations of external influence and that sort of thing. And that's what we're dealing with here today. And to quote State v. Grovenstein, which is a 19...
Internal misconduct is within the body of the jury. External interference is someone outside the body of the deliberating jury, just so we're clear on that.
99 case of the State Supreme Court. It cites Aldred and Kelly and says, we have consistently held the defendant must prove prejudice in these sorts of claims. And if we walk through all of the case law, our court has been very careful, and as much said so in Aldred, which was an internal case, to sync the analysis and the standards between those two, and have consistently held that the defendant has to show prejudice. It's their burden to do so. In Blake in 1992, the court held don't presume prejudice, and the test, of course, was whether or not the verdict was solely the private product of honest deliberation or whether it was the product of outside influence. We go over to State v. Kelly. Of course, Your Honor concurred with Chief Justice Finney's dissent in that case, but in that case, there was a...
As Your Honor so wisely concluded. Look, I'm not saying judges and justices have ego outsized from that of your average lawyer, and I'm not saying that it is a profession largely driven by ego. I would never. But citing the judge's words back to them is delightful. It's like, as Your Honor concurred. Remember, Your Honor, you did this. Brilliant when you can.
Pamphlet in the grand jury room. Clearly an external influence was alleged there. And ultimately in that case, the court held that the defendant failed to show prejudice from that particular external influence. In State v. Grovenstein, in this instance, it was clearly external. There was an alternate who was present in the jury room and even took a preliminary vote with the jurors. So clearly an external influence, far more than is even alleged in this case. That juror was removed, curative instruction was given, but ultimately the court was very clear that we have consistently held the defendant must prove prejudice. Again, the burden being on the defendant.
Natalie, 92's new.
Capital case, one that...
Natalie, let's be glad. Let's be just when it comes to jurisprudence, let's be glad they're not talking about 17 or 1892. The fact that they're talking about 1992 is basically a brand new case. That's basically new, fresh case law. We're not citing the Magna Carta today, and that's a good thing.
Argued way back when, and in that instance, there was a police investigation, background investigation into death qualified jurors in a capital case. Clearly external. The trial court conducted an inquiry with questions submitted by the...
I don't see any of the Murdaugh family members in court today.
Ultimately noted that it was the defendant's burden to prove actual bias on the part of the jury. In State versus Pittman, another case that I argued before, Your Honor. In that particular case, there was a juror who had a conversation with his wife and with the bartender. Ultimately, again, the court held that the defendant failed to meet the burden of prejudice because the wife's comment was the defendant was not guilty, and the comment to the bartender took place after deliberations had begun. And then, of course, in Green in 2020, Your Honor just commented on that, and the court clearly held that the Rimmer presumption of prejudice doesn't apply here.
I bumped myself up because StreamYard makes it easy for me to do that, so hopefully I don't cover my full face with our amazing comments because chat is bae.
And of course, went on to note that the defendant bears the burden of proving prejudice.
Oh God, you guys are pointing out my my own bias. I was in junior high in 1992. This is why I feel like it is so new. But no, in case jurisprudence, the fact that we're not going back to the 17 and or 1800s, when we get into like the 1900s, I'm happy. Like even 1930, I'm like, oh good, it's not so old. But I love seeing those of you in the chat because International Crew is the best, saying, yeah, but here we're citing things from 1592. Thank you, International Crew. You guys always make me happy.
Cameron is a case that they rely on a lot. And I would say this about Cameron, that Cameron, of course, goes on to say that the mere fact of any official communication does not necessarily mean that the jury was prejudiced, and went on again to do a prejudice analysis and a harmless error analysis. Covington is the Court of Appeals case from 2000. In this particular case, there were jurors who supposedly knew the defendant and knew some external information about whether or not he had had previous difficulties with his wife and that sort of thing. Clearly external information. And again, the court held that the defendant failed to show prejudice. So the case law in South Carolina, both from our state Supreme Court as well as our state Court of Appeals, it's clear, it's in sync, it's uniform, that is the defendant's burden
Y'all,
to show prejudice.
Again, we're at the top of live trending. You guys are the best. Thank you. I will always take second place to Lo-Fi Girl. I love it.
And again, we can address at the appropriate
Thanks,
time what the
Leonard.
state position is as to the order of which the evidentiary hearing should go.
Thank you, sir. Mr. Griffin, you reply?
Yes, Your Honor, there is a tremendous difference in the law as to how the court analyzes juror misconduct, as in Kelly, where the juror reaches out to her pastor, gets a pamphlet, brings it into the jury room, and that was found during the course of the trial. The trial judge removed juror O, who had gotten a pamphlet, ordered every juror to ask what effect that had and if they could put that out of their mind, and then deliberate. So that happened during the middle of the trial, but it was juror misconduct. All the other cases that he cited and the state relies upon are juror misconduct cases. Not unauthorized third-party communication that goes to the heart of the Sixth Amendment, right by a defendant to confront his accuser, to cross-examine witnesses who present evidence. When a third party makes an improper contact with the deliberating jury before they deliberate, that falls at the heart of the Sixth Amendment, which is a different animal altogether than where a juror engages in misconduct. And that's where you get to Cameron.
I do agree with it's a different animal. I agree with that.
Green, which Green says it was a procedural communication, not a marriage communication. And Your Honor, in Bryant, well, I would note, Your Honor, dissented in Kelly, but in Bryant, I mean, no jurors were interviewed, as best we could tell by the record. But in Bryant, it was a death penalty case. Law enforcement, I believe it was Horry County, were out questioning the jurors' relatives and friends and trying to get their belief as to whether they believe in the death penalty. Apparently, some of that kind of leaked back to one juror, or maybe, but there was no record saying the jurors were prejudiced by that. But the court said that behavior cannot stand, and we find prejudice based on the conduct, not on the juror's testimony. And they didn't use the word presumption, but they found prejudice. And I don't want to get caught up in this issue of do we have to establish prejudice? I think prejudice is established.
Sir, that's the whole fucking question. Jim, that's the question. That do you have to prove that it impacted their verdict is literally the whole point.
But the question has to be established, but the question is it presumed under the circumstances? And if it's presumed under the circumstances, what does the state have to rebut it? And so, prejudice is the touchstone, but the question is,
can it be presumed? That's fair.
Here, where there's a third-party communication that goes to the merits of the case, the law is crystal clear that there is a presumption of prejudice,
And
the state has
I
a
think
burden of
that's
proving
fair.
it's harmless beyond a doubt.
Thank you, sir.
Thank you.
All right. Mr. Waters? I'm not going to go back and forth a million times, but if you want to have a short comment and additional comment.
She is not. She's like, sir, what we're not going to be doing is going back and forth. And normally the party that bears the burden in a hearing or a trial or whatever goes first. Then there's a rebuttal or opposition, and then there's a reply, and then that is it. Creighton is like, but I'm a prosecutor. I'm used to going last.
Sure, Your Honor. He said that these were not external influence cases, and every one of them that
I can try to boost it one more
was,
time.
Your Honor, Blake was a bailiff. Kelly was a pamphlet. Again, it was an external piece of information coming in. Grovenstein, it was an alternate. Again, that's an external influence.
Is that
Bryant
better?
was a police investigation. Pittman was a bartender and a wife's comment.
Sorry
Green
for everybody
was
on
a bailiff.
headphones.
And Covington was, evidence that was not admitted at trial that the jurors were aware of. So clearly, all of those were external influence cases, Your Honor.
All right.
There is no question in my mind that this is an external influence case.
I do not regard State versus Cameron as the guidance that needs to be used by me in making a determination about this case. It's a Court of Appeals case. Since that case in 1993, there have been several cases, including Green, Oliver, and others, that very specifically talk about this issue of what the burden is when a motion for a new trial on the basis of after discovered evidence that involves tampering or alleged tampering with the jury. All those cases say that prejudice must be proved, not presumed.
Well, we know which way this judge is
And
leaning.
may very well be that is what's going to be shown. But for purposes of what the defendant must show as the case goes forward to an evidentiary hearing, the presumption simply by the contact, which we don't have any sworn evidence about except in the area of one juror at this time. A presumption is not the way to examine this issue, but rather specific evidence about what was said, when it was said, and how it was perceived by the juror is what I believe is required by State versus Green and other cases.
The judge is indicating exactly what her ruling is going to be, saying that what the defense has to prove at a hearing, because the judge has definitely said multiple times it seems that there will be a hearing. So the judge didn't say we're not having a hearing, we don't need to get to the rest of this. And trust, if the judge wasn't going to grant a hearing, she would not be wasting everybody's breath with arguing what the standard should be at the hearing that's not going to happen. She would have said there's no hearing, the rest of it is moot. But what this judge just said was that she found the Green case controlling, and she found that what the defense has to prove is what the contact was, what was said, how it was said, and how it was perceived. So the judge has told the attorneys that whether or not it impacted the juror is important, not just that it happened. The defense has been arguing a long way. We just need to show that it happened. It's not that we just need to show that it happened. It's that they need to show that it happened and that they need to show that the juror was impacted. All right, let's keep going.
And therefore, that is the approach I will take. All right, the next.
The written ruling is going to be good, but that is
inquiry,
a ruling the defense does not want. That is a ruling the prosecution wants.
Procedural argument of the state that this matter was untimely made.
I love how this judge is addressing this hearing.
Mr.
Very
Waters?
linear. It's like,
Yes, ma'am, Your Honor. And again, we have raised the issue, as I talked about earlier, that we believe that there is at least an inquiry as to a procedural bar, that if the defense was aware of these allegations during the 10 days, then it is not after discovered evidence and the motion is untimely. And additionally, we also, as I previously expressed, have raised the issue that the affidavits on their face are insufficient to put in play an evidentiary hearing. And there are multiple cases that have in the state that have held, I think Yarborough is one of those that have held that where that showing was not made, that the trial court properly denied an evidentiary hearing. So we would just preserve those issues, understanding the court's plan or procedure that you previously expressed.
All right. Mr. Griffin or Mr. Harpootlian, let me say that I will say to the defense, to the state, I believe that issue needs further exploration.
Oh.
So I am not prepared to rule at this.
Oh, ma'am. Okay. The judge said, I believe the statutory bar, the fact that with after discovered evidence, that a motion for new trial needs to be brought within 10 days. And with after discovered evidence, you have to show that you brought it as timely as possible, essentially. She said, I am not satisfied that I have enough information to rule on that. The comments of the defense are going to come back to bite them because Jim Griffin said in a press conference, we were told right after the trial that we needed to look at what was going on with the jury, but the verdict came down in March and they didn't bring this motion till September. So that's not 10 days. And this judge is not dismissing that, which is this could be a staggering loss for the defense if the judge finds that they did not bring this in a timely fashion. And if that happens, it's going to unravel because of Jim Griffin's statements to the media. Wow, 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 wow. 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 And she's not going to rule on it. So they're going to walk away today not knowing whether or not she's even going to let this go forward. I was not expecting that.
This matter is untimely in the least. We're going to have a
Justice
hearing on this
Toal.
matter, which time this issue will be further explored.
I'm going to back up real quick.
State has
What did she say? Because I am shook.
issue needs further exploration, so I am not prepared to rule that this matter is untimely in the least. We're going to have a hearing on this matter, at which time this issue will be further explored. So
she has granted the ruling, even though she has not expressly said that, and this issue will continue to be explored at that hearing. So she might say, hey, I don't find this was timely brought, but allowing the hearing to go forward. Oh, that's so appellate court of her. Oh, I was not expecting that. Chat.
the state has preserved its position, but you need not argue about that matter at this time.
Thank you, Your Honor.
Wow. That could be a huge loss for the defense.
And now the matter that to me is the heart and soul of what we're doing today is the witnesses, the exhibits, and the procedure needed with respect to the witnesses. And the witnesses, at least, are the jurors and the clerk of court, Ms. Hill. What I'd like each side to explore with me is how those witnesses should be presented, who should present them, and how they should be questioned
By the judge.
and whether there are any brackets or limitations that should be imposed on what these witnesses are asked. And I will begin with the jurors, which is really the heart and soul of the matter. Other witnesses are very secondary to the first issue, which is
I think the
jurors
judge questions them in open court. That's what I think.
Mr. Harpootlian, you are the moving party, and you may proceed.
Your Honor, we agree all 12 jurors should testify. I think both sides agree, Your Honor, the question of jurors. The only question is, not only question, but the first question would be, as Your Honor questions these jurors, would you, in all the cases the judge questions the jurors, would you want suggestions from us as to what additional questions after they respond to your questions, that raise additional questions? That's number one. Number two,
I'm holding on to your all questions.
Each one of these jurors, except of the original 12, I think all have been interviewed. Maybe 2 have not been interviewed by SWED and given statements, recorded statements. The rest have all given recorded statements. And then SWED prepared a memorandum of interview. We have reviewed all these videos and the MOIs, and I can tell the court that the MOIs aren't consistent in many instances with what was said on
MOI is memorandum of interview from SLED.
video, to the extent that information was left out. Now, if Your Honor is going to be very restrictive and ask, did the court communicate something to you, and did it affect your decision? I guess that's what we're hearing, Your Honor, when you're following State versus Green. If you're going to say that, ask those questions. I mean, there's some of these jurors who indicated they heard the court say what the juror that gave the affidavit for us say, and I think
Here's where this is going to get really interesting. If a lot of the jurors said, no, it was the court saying, pay attention to every witness, watch everything, then it's not going to be something that the court clerk did. But also, it depends on exactly what was said. If the clerk of court said every day, good morning, remember, pay attention, watch every witness, do your job, then that's different than don't trust anything that Alec Murdaugh says. This hearing is not going well for the defense this morning.
they're going to say it didn't affect them, which is fine.
And I feel like they know
If
it.
affected that one juror, we believe that's enough. And that juror had obviously given an affidavit to us. The alternate, which was excused, and we keep calling her the egg lady, but she was also excused. The alternate because she wasn't needed, the egg lady because the judge found that she had contact with people and discussed the case. They further indicated that the court said what we say she said, and we believe they should be examined. We'll be happy to do that, or the court can do that. So there are witnesses, and then we have the court herself. I talked to her lawyer this morning who indicated she's not made a decision as to whether or not she would assert any constitutional right not to testify.
I'm going to back that up. He's now talking about speaking with Courthouse Becky's attorney, and whether or not she will testify or whether she will plead the fifth.
So there are witnesses, and then we have the court herself. I talked to her lawyer this morning who indicated she has not made a decision as to whether or not she would assert any constitutional right not to testify. And obviously that would be on a question by question basis. Maybe, I don't know. I mean, we're not ready to argue what the standard is on the Fifth Amendment this morning. But if she does testify, there are literally thousands of emails we furnished last week by Colleton County, some information furnished by SLED this morning and the Attorney General, which might be.
I wonder if this is more emails than the FOIA request, because I have been going through the 2,000 plus pages of this clerk of court's emails. Woof.
Be utilized, I can't say right now what it would or wouldn't, depending on her answer, to impeach, to contradict. So I can't tell you what exhibits there would be or what we would do because I don't know what her answers are going to be. We believe we should be able to examine her as a hostile witness. We should be able to call her as a witness.
You generally have to prove that the witness is hostile after you call them. That's generally the procedure. I think that's putting the cart before the horse at this point, Poot.
Because the burden is on us, as Your Honor just enunciated. Now, the only other thing I would say is this. Even if Your Honor determines that a piece of evidence or a question is not admissible for your consideration for purposes of the appellate record, we believe we ought to be able to make a proffer. So it may be.
He said proffer.
That Your Honor allows us to go forward, and then in your decision decide it's not relevant. In your decision decide you didn't consider it or whatever. But stop and go is going to elongate that hearing dramatically. And again, since you're the finder of fact, you can decide not what a jury's going to hear, but what it matters to you. So we think that the examination of the court should be wide open, and we think that the exhibits we would use to impeach her, we would attempt to keep it relevant.
We'll
to
chat hostile
the
witnesses at a
specific
break.
issues in this case. I mean, her son has been indicted. For instance, her son's been indicted for wiretapping. There seems to be some inference.
She's admitted to plagiarism.
What we read in the papers, we don't have any specific knowledge that she was aware of that, and the wire.
If you don't have specific knowledge of it, maybe we don't bring it up in court though. Maybe we don't bring it up in court though. Poot, you're not giving legal commentary. Maybe don't bring it up in court.
Wiretapping was in relation to some ethics complaint about her. That's not relevant. We're not going to ask her about it. Now,
You just want to put it out there.
we're continuing to examine whether or not there is some connection there, and we're investigating that. But at this point, I would tell you that's not where we're going. Where we are going, by way of example, is we have been furnished an email that she got.
Where are we
February
going?
24th from somebody, which was a photo, a screenshot of a looks like a posting on some sort of Facebook page, where the ex-husband of a juror, not the egg lady.
What are we talking about? Poot is in the weeds talking about an email of a screenshot of a Facebook post of an ex-husband of not the egg lady juror. I'm backing up. I'm trying to follow him. He's not as linear as Jim or as Creighton, and it makes my ADHD jump the tracks. Okay, hold on.
Which was a photo, a screenshot of a looks like a posting on some sort of Facebook page, where the ex-husband of a juror, not the egg lady, alleges that his ex-wife has been talking about the case, and she is going to vote guilty because she hates men.
The ex-husband of a juror in a screenshot, in an email, in the solarium with the candlestick, said that she hates men. What? Poot? What? Sir, what is happening? Of an ex-husband of what juror? What? This is not the egg lady thing. He said not the egg lady. I don't know what in the world is happening here, but good Lord, because she hates men. He's like, Your Honor, good God, what in the weeds is happening here?
Now, we know she got it. We know she got it on February 24th, yet on the morning of February 27th, she tells in the chambers, the hearing we were all present at, that she had seen a Facebook page posting by egg lady's ex-husband alleging that she was talking about the case, and she didn't think he was guilty.
Have you ever had a child come home from school and try to explain to you drama going on with people you've never met? I imagine that this is exactly how Justice Toal is feeling when Poot is like, okay, so Your Honor, not the egg lady juror, okay, but another juror with an ex-husband that hates men, not egg lady. Oh my God.
That Facebook page had never been produced, and then she produced a Facebook posting, she said, by the egg lady's husband. Turns out to be a guy.
The rumors,
apologizing for
the nastiness.
which concerned his wife's aunt meddling in their marriage.
His aunt's wife.
Fertile ground for cross-examination. Your Honor may disagree with me, but I still would like to put those items into evidence for the appellate record at the time. The last thing I would say is this. In terms of Your
Somebody's
Honor,
sister's
questioning
cousin's
jurors,
boyfriend's uncle is going to get involved.
as to whether you want, if you finish with the juror, do you want us to submit questions to you? Do you want? I doubt you're going to let us question them.
In the Maxwell case and in the Maya case, so therefore it should also happen in the Murdaugh case because the judge questions the person, and then the person is excused. The judge solicits questions from the lawyers and then goes back to questioning the person if needed.
How is that process going to work? And will that be done someplace? Will it be done in this courtroom? Will it be done somewhere else?
She asked you to answer these questions, Poot, not to raise more questions.
Will there be a way for the public to hear what they have to say? Thank you for your intelligence.
Receipts, proof, timeline, screenshots, receipts, proof, timeline, screenshots, the evidence. Sorry for all of these not watching Real Housewives of Salt Lake City. Since this is paused, we're going to take a minute while Jim tells Poot what else to say. Don't forget that we have an app, the Law Nerd app, that will keep you in the loop with when I am streaming, where I am streaming, what I am streaming, and will be the best place to keep up with all of my behind-the-scenes shenanigans this week. So,
Mr. Griffin rightly points
free
out,
app,
it's
iOS,
not
Android.
just what they heard, may have heard from the court, but did any of the other jurors, for instance, egg waving, if you call her,
Not a deliberating
an
juror.
affidavit indicating Becky said things like, "Don't be fooled. Watch the body language. Watch body language testifies to Mr. Murdaugh." Did she relay that to any other jurors? It's not just what I mean. Was it? Did it? Or did the sitting juror or the alternate
If you have to prove that the statements impacted the verdict, the alternates are not going to be relevant. They're trying to make the alternate relevant by saying the alternate might have overheard something, but it can't impact the verdict if the alternates, didn't make the verdict. So
the
I love it. Charlotte's like, I've missed this stupidity so much. I think they should have just let Jim argue. I think it works really well. I am ready for all of it. But Law Nerd app, free, iOS, Android, keeps you in the loop with everything I'm doing. We'll keep you in the loop with behind the scenes in my travel and tomorrow's podcast episode, which is all about Leah Remini versus Scientology, which also has a hearing today. Today's like Court Super Tuesday.
in the memorandum of interview now, the Clerk's private lawyer, Mr. Lewis, objected to any videotaping or audio taping of the Clerk when she was interviewed. But in the memorandum of interview, the Clerk indicated she had conversations with the four-lady outside the presence of the rest of the jury about what was going on in the jury.
Remember, while Poot is knee-deep in chisme, the court asked, what is the procedure for questioning the witnesses? He is giving the court all of the details of like who said what to who, but what he's not doing is answering who's going to question the jurors. He is like filibustering at the moment.
Jury room. Obviously, I would cross-examine her on that, but it may be necessary.
You can't.
If she testifies to things that are inconsistent in that MOI, for us to call the sweat agent that did the interview to corroborate the MOI.
That's not what she's asking. Can you answer the
MOI
question the
may be
judge asked?
In and of itself, exception to the hearsay rule, but I believe it may be necessary for us to call the sweat agent. We're not going to, and Your Honor, you've indicated that you're not going to want to know any sort of summaries of those interviews about the jurors, when we talk back to Chambers, or necessarily the MOIs. You want your own fact-finding with the jurors, to the extent that they
It's literally the point, though. It's literally the point that the judge does the fact-finding here.
contradict those. We may put all of that into the record for appellate purposes. And if you want to see those before you have this hearing, we obviously put those. We could put those in the record today, or have those available to you, both the MOIs and the videos. We're obviously we're going to do whatever you tell us to do, but we're looking for some guides as to if there's anything we can get you prior to that evidentiary hearing concerning those memorandum of interview by the SWED agents and the videotapes. Whatever you instruct us to do. Thank you for some intelligence.
We are pooting along. That's exactly right, Vexation. We are pooting along. She's letting him put what he needs to put on the record, but I'm like, come on, Poot.
Mentioned, and Mr. Griffin reiterated to me just now.
It's not just you.
And obviously you don't need to tell us this today because we're not going to be doing the questioning, but there is the consideration of 606B and the incursion into deliberations. At some point, we don't need to know that today, but at some point prior to you questioning the jurors, we'd like you to enunciate what your position is on that.
You're going to have to outline that a little bit more for me. What part of 606B are you discussing?
Well, it says, if I can find my glasses.
Poot's given all the information to the judge.
Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind as or emotions as influence a juror to assent to or dissent from the verdict.
All right, and what are you saying that imports for this procedure?
Well, I mean, for instance, if we prove to you that the court said, do not be fooled, or, watch Murdaugh's testimony, watch the body language inferring he was.
If what Courthouse Becky said was watch the testimony carefully, you're not getting a new trial, Poot. It feels like he's backtracking a little bit from what was in the motions because his arguments about what was said to the jurors is kind of walking it back a little bit to watch the defendant's testimony. That's a whole different situation than don't be fooled by anything this defendant says.
Lie, he will be lying.
That's more important.
One of the issues is if the juror who sat during the deliberations who said that
he likes an audience.
Said that, did she discuss that with any other jurors? Did she infect the jury? Does this allow you to do that?
Well, you certainly, if you go to 606B, it gives you some guidance about that. It says, an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of
yes, Your Honor,
on that or any other juror's mind or emotions influencing the juror
accurate
or dissent from the verdict or indictment or concerning the juror's mental processes, except a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention or whether any outside influence was improperly brought to bear upon any juror, nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which juror will be precluded from testifying be received for these purposes. I take that to give us the guidance we need about the parameters.
Hey, Pooch, she said the law says what it says.
But if the juror that gave us the affidavit, would she be?
The law says
asked,
what it says.
Did you discuss that during deliberations? Did she do that?
You can't ask that.
Apparently, is very questionable under the terms of 606.
I don't think it's questionable under 606, Your Honor. I don't think you can ask that because it gets into the mind of the jurors during deliberation. Just my opinion.
And I intend to abide by that. The way those questions have been asked in many cases I have reviewed is to ask the juror whether that's still their verdict. If they ask about improper context and they talk about improper context, then the way to pursue it beyond that for the judge is to ask about the impact on the verdict, not on the deliberations themselves.
Accurate.
That may be a small slice of difference, but I think it's very important to understand that no one, not myself or anyone else, is going to be asking the juror about the specifics of their deliberation, and the rule is quite clear about that.
Okay.
I think it's not a small slice of difference. I realize that lawyers argue over two different words, but these have substantial meanings. This is not a small slice of difference. So I appreciate the judge. Poot wants to get into it, but the judge said you cannot ask what the jurors talked about with each other. You can ask if it's still their verdict. You can ask if anything improper was said to them, but you cannot invade the sacred jury room deliberations and ask questions about it. The law is very clear on that. The federal rules that the state rules are modeled after is very clear about it. There is no exception to that.
And is it clear that you will not be using the SLED interviews or MOIs to attempt to impeach?
I told you when that was brought to my attention in our Chamber's conference this morning, I haven't made my mind up about that. I don't know what's in those.
We don't know what's going to happen.
Anything else, and we're going to have to discuss that. But again, I'm the one doing questioning at this point, Mr. Harper.
Yes.
And I'm trying to perceive what you all are asking, and I'm going to go to the state now and see what their reaction is to what you said.
Thank you, Your Honor.
Mr. Waters?
She very graciously told him to sit down and that he was done.
Your Honor, again, we would concur with what Your Honor just said about Rule 606 and, of course, all the cases that we've talked about, and the need to show prejudice. And obviously, when you're talking about external influence, that prejudice, which will be an appropriate subject of inquiry to the jurors, is whether or not there was an impact on the verdict. And we, of course, have suggested to Your Honor, not only based on the cases, that should be judicially conducted in a manner that protects the privacy of those jurors and that protects the privacy of their identities. These jurors, were drafted into service, and this inquiry, of course, has to happen, but it needs to be conducted in a manner that respects their privacy and should be, of course, judicially conducted. We have suggested those two questions. If we look at the Bryant case specifically talked about the fact that depending on how the examination goes, there could be questions suggested by the parties. And obviously, I think we would need to cross that bridge if and when that bridge needs to be crossed. And that starts with the court's inquiry to those jurors, and only if something arises that needs further inquiry could that be addressed at that point. And that could be even a discussion from counsel with the court as to what additional questions may be proper. When the state first became aware of these allegations, the first thing that we did was have SLED do an independent investigation, and the goal was good, bad, or ugly to get to the bottom of what, if anything, happened. And the result of that is why we're still here today. And that is that in speaking with the jurors that spoke to us, that the balance of the evidence, as well as in talking to the clerk staff, was that there was no impact on any verdict. There was nothing unprofessional or untoward that happened that had any effect on the verdict. And so when we did that inquiry, and that is what the jurors said, that is why we're here today, and that's what this hearing is going to address. The only juror that we have is the one who filed the affidavit. That's 630, and even that person only said that she, eventually voted guilty because she felt pressured by the other jurors. Did not even mention any external impact. And so unless she's going to change her story, that is what was in her affidavit.
And that is allowed. I voted guilty because I was pressured by the other jurors is literally the process of jury deliberations where people are like, but what about this? And what about this? And did you consider that? And blah, 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 blah. That's jury deliberation. They can't get into that at a hearing. The law forebodes it. They can't even ask about that. They can only ask about, did what the court clerk say, if anything, impact your verdict? And if they say the clerk of court said X, but it did not impact my verdict, then we are done. That's what's happening here.
So the balance of the evidence is the reason why we're here today and why this hearing needs to take place. Your Honor, as far as inquiry to those jurors, again, there could be a need that the parties would suggest questions, and it could be, depending on how things go, that the affidavits or maybe even the recordings, all of which have been provided to the defense, the full recordings of those interviews of any potential witness in this case have been provided to the defense. It could be that issues could arise from either the state or the defense as to impeachment, and we can address those issues as they arise under the appropriate rules, 608, 613, and the like. Dealing with not only
under the rules of evidence,
prior inconsistent statements, but other evidence that would be properly impeachable. Ultimately, I do need to address one thing as it
Thanks,
deals with all
Reed.
of this, and that is the defense's contention that somehow the clerk is a party opponent in this particular case, and we believe that that is incorrect. Obviously, there is a hearsay exception or a non-hearsay determination in the evidentiary rules, I believe in 801, that excludes statements of a party opponent. But just because the clerk is an elected official and of the state, that does not make them a party opponent.
Yeah, they're not a party
the way
opponent.
that term is defined. A party opponent is an active litigant before the case, and that is, I think, different. So we would certainly say that the hearsay rules would.
Creighton's like, not a party opponent. She's not with us. Look, Colton County elected her. We are the state AG's office. She is not ours. It's funny.
Still be in effect as it relates to Ms. Hill and any testimony that she may provide. I know there's been some discussion about the order in which the witnesses may be called.
Agreed. She still is the government.
Be a hostile witness, and obviously that's under Rule 611 and I believe C, which will allow leading questions. If a person is hostile.
He's
I
linear.
think, again, at this point, I don't know that any showing necessarily has been made, but I understand the defense may raise that point, and we may have some arguments at that time. But I don't know that there's been such an identification between Ms. Hill and the state that would allow, her to be identified as a party. I think that's far out of bounds, but also that she would be applicable to allow defense leading questions under 611.
Pacific, it's hard to say clerk
Your Honor,
over and over.
In looking at the type of examination that would need to happen here.
Someone's answering the question.
Also was arose of the Fifth Amendment, and I know that the defense would like to brief that issue, and we're happy to respond.
Yes.
We don't know exactly how that might arise in the course of any examination. We need to cross that bridge again when we get there. We would say, though, that the Fifth Amendment is question specific, and so again, it may be something that this court has to rule, as is in any sort
question
of
by question.
presentation, question by question. Based on any objection by the parties. So it's kind of hard to say exactly what the blanket position would be until we actually get to that determination. Ultimately, the defense referred to some information provided this morning. Actually, both sides exchanged last night their communications with the clerk during the course of the trial. So both sides did that last night, and there were a lot of communications with the defense as well. And so again, I just want to point that out that there's any sort of allegation or insinuation that the state's not providing information. We've been very diligent about providing.
I don't think they said that in court today.
To the defense, and if any additional information arises, we will continue to do so. But both sides exchanged that last night, and of course, there's been some reference in their filings as to emails that were forwarded from the clerk to me and to my paralegal, and they've actually even listed me on the witness list. And Your Honor, as we have had a
for those of you that have not been following this case this closely, Creighton is referencing what was brought up in the filings and the motions by the defense is that the clerk of court, Becky Hill, was getting a ton, and I know this because I was reading the emails, was getting a ton of input from the public, as happens during these big trials, but was forwarding some of that information along to just the prosecutors, which has an appearance of impropriety. We talked about that on another stream. We can talk about that more later. But what he's referring is to people were emailing in about like cross-examination. We're like, you need to get this info to Creighton Waters. And she was forwarding it to him, just him, not to him in the defense, not to him in the court, not to no one. And that's was brought up in the motions. And then Creighton Waters was put on the witness list. That's what he's talking about.
Chance to peruse the defense communications with the clerk. There was just as much communication and offers of help. It was just a uniform across the board courteousness that's reflected from those. So we think that that's a non-issue.
That's a mild way to put it, Creighton. It doesn't look good, though.
Arises during the course of this evidentiary hearing, at least as it would require communication from or testimony from an attorney.
Tina K.S. Leonard, thank you for the gifted memberships.
Ultimately, as we look at the inquiry that will need to be conducted, as the state has made clear, it starts with the jurors. And only if something arises in that inquiry, further inquiry to those jurors may be necessary. And that could be in discussion with the parties, as I've stated before. And then I know Your Honor has indicated the clerk should testify, and we certainly understand that. The clerk filed an affidavit denying any of these allegations. And so, again, as we address the clerk's testimony,
Thank you, Betty.
the state would have objections to some of the information I believe the defense would propose to examine her on. We believe that an inquiry should be limited to what is appropriate and relevant impeachment, but not should be just a far-ranging fishing expedition or full come up since the trial that we believe are not relevant to any inquiry that is before the court here now. Obviously, rules 404, 401, 402, and 403, as well as, which of course address relevance, and 403 objections, 404, which addresses other crimes or wrongs or acts, Rule 606, 608, which addresses inquiry into other specific acts and impeachment, and Rule 613, which
The
talks about
feed's a little
prior
fuzzy. I think
inconsistent statements.
it'll
All of those
clarify
rules
itself in a
potentially
minute.
could come into play depending on the nature of the testimony and the nature of the inquiry. But there have
We
been
can hear.
allegations
That's what matters.
since the trial about the book, about this wiretapping case, about investigations into alleged use of office for
Creighton, because it's sus as fuck. That's why, man. The reason that all of this is such a disaster is because the clerk admitted to plagiarizing part of the book from stuff that came across the email. The son, who was the IT director for the same county, is now been indicted and charged on wiretapping. There's allegations that wiretapping was directly in relation to ethics complaints regarding Miss Hill. She's been accused of using her office for her own profit. She wrote a book where she refers to herself as like the royal we with the jury. There's a lot of shit here, Creighton, that's weird.
improper gain. But again, all those are subsequent to the trial. And so again, depending on how the testimony goes,
They are
the state
subsequent
would
to the
raise
trial.
appropriate objections at that time
True.
to limit the inquiry to what is appropriate for
True.
what is before the court we would submit. And that is what occurred during the trial. So we would make those particular evidentiary objections as things developed. Ultimately, that would be the state's position. I know that we're trying to put as much meat on the bones as we can at this particular point in time, but I think the reality is that the court's inquiry to the jurors will really determine the nature of the inquiry that needs to proceed from there. And at that point, the state would take the positions that I've outlined here today.
Thank you, Creighton.
You reply.
Please, court, Your Honor.
Oh, poot. Thank you all for the gifted memberships. It's truly appreciated. This community is amazing.
I find it somewhat ironic. The state is quoting Rule 404.
404 does not mean not found. It is a rule of evidence. He's going to get into it now. Just know that 404 does not mean Poot's not found. Poot is not 404ing himself.
Your Honor, one of the exceptions to 404, I know this will be surprising to Mr. Waters, is motive. As if he's never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book.
Look at Jim's face. The prosecution told me this morning that Becky Hill told an assistant that a guilty verdict would be good for sales of the book. I think a hung verdict would have been better because then there would be a second trial and then it would end on a cliffhanger. But it's a soap poot. The reach. Okay, I'm rewinding this. It's too good. And I know the court's on a break, so we'll be able to zoom past the break. He sat down and gathered himself and he was like, where is the zinger? Here it is. A guilty verdict is good for sales of the book. I will say that going through Courthouse Becky's emails, I have definitely seen emails that indicated she strongly believed a guilty verdict should come forth in her emails to others. But that doesn't mean she tampered with the jury. This doesn't mean she tampered with the jury.
This will be surprising to Mr. Waters. Is
However,
motive.
I'm amused, so I'm.
As if he's never heard that before.
Emily will allow
He
it.
told me this morning one of the
Amused.
assistants that worked
Amused.
for Ms. Hill during this trial was
Amused.
told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book.
The rumors.
Motive,
Nastiness.
selling books. So we believe we should be able
Somebody
to get into
auto-tune
that.
the poot.
We should be able to ask Ms. Hill about it. If she denies it, to call that witness, that assistant, and have her testify that she was told that. I mean, why would a clerk do what we allege she did? We think is important for your honor in terms of credibility and context. That's number one. Number two, your honor, I think we've all agreed, you're gonna ask the question,
I'm here for the drama.
whether we agree or not. And we do agree with that. The question's going to become, as we go through that process, how, if a juror says X and they've said in their interview Y, or if they've said to us Y, or didn't include it in their original affidavit, and you don't ask that question
Oh, it's hearsay.
initially,
It's gossip at
how
this
are you
point.
going to handle, or do you care how we suggest to you a further question? Because as your honor's seen this morning, the back and forth can go on for a while. And we certainly don't want that to go on.
It's a great song.
So we're gonna need some guidance on that. I'm not expecting that guidance this morning. The last thing is, as these jurors are examined, I need to understand a little bit about the logistics. Are we gonna do it in this courtroom? Are we gonna do it in another courtroom?
Can we do it with a mouse? Can we do it in a house? Can we do it here or there? Can we do it anywhere? I do not like green eggs and ham. I do not like them, Justice Toal. Poot, the original question, just so we all remember where we're at, the original question was, what is the procedure going to be? She asked you to suggest it to her, not ask more questions. Poot's like, Your Honor, I've got questions. I need to know, like, book sales are good with a guilty verdict, but where are we having this hearing? Can we get back to the procedural part, Poot?
Is the public gonna be able to hear the responses? Will there be an audio feed if we do it somewhere else? Are you not going to have cameras turned, you can do it in this courtroom, have cameras turned off? And we're obviously not gonna refer to jurors by their names. Even though 3 of these jurors went on the Today Show, another one went on ABC, they were all in the courtroom.
Are you jelly, Poot? Do you want to go on the Today Show? Is that what this is
In
about?
the courtroom, all except one of them, for the verdict. Cameras were there then. Again, I'm sensitive to their anonymity, but I don't know that any of them have any real anonymity anymore. Saying that, I think it's important not only for your honor to hear their answers, but for the public to hear
Deb, this
their
is
answers.
true.
Thank
It's
you.
true. It's
Thank
true.
you.
It's true. I'm entertained by the lawyers. It's true. Poot definitely doesn't get paid by the word, but he is a politician. So there are times that we get the filibustery politician on the floor vibes from Poot, for sure. I'm going to get to questions when we get to a break, but the court has gone through all...
With respect to the jurors first as witnesses, I will be doing the questioning of the jurors. And I will notify the parties pretty promptly what I intend to ask the jurors.
That's what I've seen happen in every court that has to question jurors. Every single one does it that way.
The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked the jurors on 2 levels.
That's the heart of the question. So I appreciate Justice Toal saying the heart of the question is, what contact was had with the jurors? Did it impact their verdict? That is what needs to be asked of these jurors. That is it. Fin.
One, as a predicate to what you want to do with the clerk herself in examining her. And 2, as a means of further attacking the credibility of the clerk in
It
her
just
testimony.
depends on if she testifies.
I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth.
Oh, I love the jacket. I think that's the clerk's paralegal down in the front, or the court's
We'll be open
research
to
attorney.
receiving that if it's done
Cute
promptly,
jacket.
because we've got a hearing coming up the 29th, and I want there to be plenty of time to revise any current ideas about who to subpoena, who to call as witnesses, and who has to do that. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been
Good.
improper on its own.
Good.
Indicative of her characteristics, her personality, or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury. So,
Good.
I am
Focused.
very mindful of the limited nature of it.
Focused
As I
inquiry.
say, I'm not excluding submission in advance of information that would take the questions beyond the limited questions I initially indicated. But I will be very hesitant about any of those questions as it involves propounding those questions to the jury. As it involves questions to Ms. Hill similarly, this is not a time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am the judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary,
The law is
nor do I
being
think it's
laid
proper
down.
to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be used. I can't imagine allowing thousands of emails to be made exhibits in this process.
But Your Honor, we're nosy. If you make them exhibits, we'll all see them.
Either emails sent by her to attorneys in the case,
Not relevant at all.
to other court officials in the case.
We're just nosy.
Individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical, dealings with the county, and so forth. This is a very focused inquiry about this jury and its ability to render the verdict it rendered in an impartial manner. So I say that to tell you that when the clerk is offered, and I think the clerk is going to have to be offered as a witness, the whole allegation revolves around the contention that the clerk made contact.
I mean, if the jurors say the clerk made contact and the court clerk refuses to testify, the only presumption the judge can take from that is that everything's true. So I don't know if the clerk has to testify. I think there might be a reason why the clerk might not want to testify, but I think the judge is absolutely tipping her hand in letting the lawyers know what she's thinking, which I love.
With the jury about matters material to their verdict, that contact was improper.
It's molasses and
that it
smooth,
impacted their verdict. there's a whole lot more that
Cuddled on this snow day with everybody else.
Mr. Harpootlian has indicated he'd like to explore that I regard as totally extraneous to the inquiry that we maintain. I'm not going to allow those questions to be asked by way of proffer and then have the clerk answer those questions and have that be the proffer, although I consider them irrelevant questions. We're not going to handle the case in that way. If I exclude
Justice Toal's not here for the
a
fuckery.
certain question from being asked,
It won't be asked.
then the proffer will be whatever in writing is chosen to be offered in that regard. But I will not conduct a hearing where there's a whole side hearing in which every question desired is asked and either required.
I think this judge paused when she said there's not going to be a whole side hearing. I think she was thinking sideshow in her brain, but they are not going to make a sideshow of going after this clerk. It is going to have to directly relate to conduct with the jurors. And the court also noted that she's the one who's judging the credibility of the witnesses, and she might not want to get into the plagiarism and the rest of it because it's not relevant for her. So this judge is making it very clear that this is going to be a limited and concise hearing of these witnesses.
To be answered.
I'm here for it, Your Honor.
Or
I like it.
dealt with in some other way.
I like it.
I don't think that is an appropriate use of this very targeted hearing that I'm directed to have.
Very targeted, concise,
I also
precise.
think it makes a great deal of difference whether the questions that are being asked relate to the clerk's conduct at the time this case was tried, as opposed to other conduct at a later time or in connections with other things than the trial of this case. So I will be looking very carefully before we conduct this hearing and trying to give the parties as much advice as I can about what I would find to be acceptable topics to pursue. I think you're entitled to that.
She
But I
doesn't want to
also
pursue
think
stuff
the
that
record
happened
of the case,
after the trial, stuff that happened during the
not to
trial.
be used as a platform to explore each and every fault of each and every witness, whether it be the juror or the clerk.
That's
And I'm not
fair.
going to have the hearing conducted in that manner.
That's
I think there
fair.
are other ways of preserving topics that I rule should not be pursued than having those questions asked and answered, even though I ruled that they are not proper in the hearing. So I hope that explains kind of where I am on the subject of how questions are asked.
I like it. I like the boundaries. I think Justice Toal has done a really good job of telling them exactly what this hearing is going to be and how limited it's going to be. Love
Some
it.
of the suggestions that are made in the filings you've made with me about the additional witnesses you'd like to call and subpoenas.
She's talking about
I think
Judge.
be sure we're all on the
Newman.
same page about what is acceptable in evidence and what is not. But I can tell you that I would not allow the subpoenaing and examination of attorneys in this case, of the judge who heard the case.
I'm backing up because she's talking about what she is not here for, and that's important.
I can tell you that I would not allow the subpoenaing and examination of attorneys in this case, of the judge who heard the case, or any of those type of witnesses. This case is.
I am not allowing the subpoena or questioning of the judge in this case, Judge Newman, the attorneys in this case. She is not having it at all. Limited hearing. Who said what to the jurors? Did it impact their verdict? The end.
Very focused on the jurors and the clerk of court.
Fair.
As I see it.
Fair. Narrow hearing. Fair.
Now, it's about 11:15, not close to it. I'm going to do this. I'm going to take a break for a minute. Let's take until 11:25 as a break. And in that time, I would hope that you formulate the other things you think we need to look at by way of the specifics of how this matter is to be
Yeah, the
conducted.
feed froze a little bit, but we still have the
I will then
audio.
do two things. When I come back and ask you for further ideas, both sides, as to who should be called, get very specific about who can be called and who cannot, who should offer these witnesses. And I would also at that time ask those who represent potential witnesses in this matter to come forward and have a conversation with me about your position on behalf of your clients. I think that's particularly important because as we have the actual hearing itself, I've never heard of a situation where a witness can have their lawyer actively participate in the examination of the witness.
They
in a
can't.
proceeding in which the witness is being offered.
They can't.
So I would not allow that, but I think we can protect the legal positions that attorneys for witnesses want to take and need to take and want to put on the record by pursuing in the way I've just outlined, and I'll be prepared to do that when we return. All right, court will be in recess.
Thank you, Your Honor.
Thank you, Your Honor.
Justice Toal is the first female Chief Justice of the South Carolina Supreme Court. And because she was a justice on the Supreme Court, she is still justice. It designates between the level of judge. Not all states adhere to that. But particularly when you get to higher levels of court, they get very prickly about their designations. So it's also a sign of respect for the work that they did. I'm going to turn the volume in court down as Alex being let out because I kept pausing to give commentary. I'm going to zoom past this break because we'll be back to live court. But that is the difference between judge and justice. It denotes that she is a retired justice of the Supreme Court. Not all states will have retired justices of one court be called in from retirement and go sit. South Carolina is a much smaller state than where I practiced, so it is a very different situation. But she is a retired justice who has been called out of retirement to sit and hear this case and is doing it. And that's what we're seeing. So we're going to get back from this break. I'm going to scrub past the break and get back into live court and see what Justice Toal has to say. Let's see. Alec is back at the
More specific look at
judge is
how
back
it-
on the bench. Let's back up real quick. I'm going to give a good zoom so that we have a timestamp for replay crew. Replay crew love you the most. That is why we are timestamped. I am going to answer questions at the end since I talked through the break. So let us swoop, and we're going to come back from the break and see what the judge has to say about how and when people will be subpoenaed before we round out this hearing for the day. Yay. Again, we are pulling the court feed from Luna Shark, who has kindly shared it with us. They are part of the media pool and have someone present in court today. I am very appreciative of independent media working together. It is so very helpful. Justice Toal is coming back out onto the bench, and we should have sound here in just a moment. Mama Kay said she's a no-nonsense judge. I like her. I like her too. I'm living for the justice's accent. These slow Southern accents are so pleasant to listen to. I love them too. I'm here for all of it. The jurors. For those of you new, don't forget to do the YouTube-y things. This is where everybody comes for live court coverage. And if you want to...
Before we proceed further, a few other things that you've asked about that
The app will keep you
I
on the
want to clarify before we then go forward with a more specific look at how witnesses will be questioned.
Yes, I'm taking notes. It's the only way I will remember to summarize this later.
First of all, how the jurors will be questioned. Everything will be done in open court.
Okay, Your Honor. We have seen this in other courts. We have seen this done every case where we've seen jurors questioned. They've been questioned in open court. Of course, in federal court, we don't have any video of it because federal court. The jurors will be questioned in open court.
The jurors will be referred to by number. The court TV cameras, which are the ones used to film these proceedings,
Won't film the jurors.
will not be allowed to focus on the image of the jurors as witnesses. And if there's some need to further obscure the way they are presented, we can talk about that. But they'll be examined right here in the courtroom.
We can just do an audio feed while they focus on Murdaugh. I think that's fair.
As other witnesses would be. And I kind of looked at a little bit of exchange we'll have with attorneys for the jurors to see what we can work out about exactly how the jurors are presented. But everything will be on the record here in open court with measures taken to ensure the privacy of the jurors. No photographs would be permitted of the jurors.
And remember, this trial was in session for over 6 weeks with tons of audience members coming in and out. People saw the jurors if they are present in court. People are allowed to see the jurors if present in court. If you walk into a courtroom and watch a trial, the jurors are sitting there. They're not like behind a shroud or anything like that. So they're just preventing that image from being transmitted across the internet, which I think is a fair balance.
Or anything of that nature. And I believe if I announce that in advance, the press that are present, the press that have covered this proceeding throughout have been respectful of the judge's requests, and I'm very confident they will be in this matter as well.
Yes, we've got audio, but the video froze a little.
The alternate jurors. I will question only the jurors who sat and considered this case.
That's fair.
So the alternate who was dismissed by the trial judge. That alternate did not participate in any way in the deliberations about this case. There's nothing that's been brought to my attention about anything the alternate might have done that was improper at all in terms of communications with fellow jurors. Nothing's been alleged.
Team Murdaugh did not want this result. Team Murdaugh wanted all of the jurors to be questioned, but because the judge said that the proper legal standard is whether it impacted the verdict, what the non-deliberating jurors have to say is irrelevant because it can't have impacted the verdict because they didn't deliberate. That is not going to be well received by the defense. That is not what they wanted to happen. That's a big deal.
So our focus will be on the jurors that heard this case and not on either that alternate or any other alternate juror that has been proposed for questioning.
Focus on deliberating jurors.
With witnesses or testimony, I do not allow. Let me explain about proffer. Proffer will be a written proffer by the party dissatisfied with the limitations of my ruling. But there will not be some examination as to proffer. The proffer will be a written proffer by the attorneys in accordance with their positions about witnesses and testimony.
Okay. The judge had said that she will take a written proffer about what the testimony would be from the dissatisfied side. So she's allowing the defense to be heard once more by a written proffer, which is a written, here you go, versus bringing them on the witness stand.
With regard to the subpoenaing of witnesses, the parties should subpoena these witnesses. And when it comes to the jurors, I would urge that the parties, the state and defendant, jointly deal with the issue of subpoena of these witnesses. I do not think it is the court's place to subpoena witnesses or order witnesses' appearances.
The court has said the parties need to subpoena the witnesses and they need to work together. The court is not subpoenaing them.
This case is driven by the parties and their positions. The initial position of defense was that only certain jurors should be called. The state said no jurors should be called, but if you do, all should be called. All who sat on the case should be called. If the party...
Wow. So again, siding with the state or with the state's argument, if you're calling one juror, you need to call all the jurors. Wow. So they're going to subpoena all of the sitting jurors. Now, we know that some of the lawyers in the courtroom present for today's hearing represent some of those jurors and might want to object or make motions to quash subpoenas. The judge is going to call in all of the deliberating jurors. I don't think I have ever seen every deliberating juror pulled in after a trial. I'm sure it's happened somewhere, but I have never seen that happen in a case. So yeah, not Egg Lady, not the Egg Lady juror, but literally everyone else. That's wild.
I just can't agree on how that subpoena should be accomplished. And
The state should do
I'm
it.
sure they'll let me know, and I'll try to take some.
The state should subpoena it. The state has the resources to subpoena it, but it is the defense's motion and it is the defense's burden, and the state can say good luck, but she asked them to work together, so the state should probably do it.
Measures in that regard. The concept I would have is that the jurors would report to a place that I will specify, and that when they report, they would be taken to a room with appropriate supervision by court personnel, and then called individually to recite their testimony. And then when their testimony was complete, they would simply take their place in the jury box until all were questioned. And then if there were any questions further by me that would be collectively made to the jury, I could do that.
Wow.
And if there are any further questions that were submitted to me by the parties that I chose to question, I would do that. And then when all of that was complete, the jurors would be allowed to be dismissed. So that is how I would handle the juror witness portion of this. And of course, I know I'm going to get some commentary from each side about that. That's why I talk about this in advance. The other witness that surely needs to be called because of the allegations made is the clerk of court. The state has submitted a preliminary affidavit by the clerk of court, and the defense has many.
The court has moved on to the statements from the clerk of court, which is wild. So now the judge is going to break down what may or may not be anticipated from the clerk of court. Remember, the argument from the defense is that clerk of court Becky Hill can't plead the fifth because she's already submitted an affidavit in the case saying, I didn't do what you're accusing me of doing. So the court is starting to address those arguments.
Affidavit by the clerk of court, and the defense has many areas that they want to explore for the court. Again, I would like for the parties to develop some joint way of subpoenaing the clerk of court. And if I need to be a part of that, then I'm sure the parties will let me know. But I say this for the benefit, particularly of the attorney for the clerk of court, to know that I would expect that the clerk of court will be called as a witness in these proceedings, 29, 30, and 31 if necessary.
We're going to see Becky Hill called as a witness at this hearing later this month. Whether she will testify or not is a whole different thing, but we're going to see her called as a witness. Wow.
We'll be using the same courtroom for these proceedings, this courtroom. And 3B will be used as an overflow.
Poot looks pissed. Does Poot look pissed to you? Poot looks pissed.
Excuse me. 3A is the one over here, and that's the one I'll be using to conduct the hearing. This courtroom we're sitting in now will be an overflow courtroom for press with I'm sure, a court TV monitor that's available for them to monitor the proceedings if there's not enough room. Based on the attendance today, it might be plenty of room. But we'll see. We'll have this I will try to figure out a way to be sure that the broadcast in here of the proceedings will not interfere with the conduct of the hearing past this partition next door. It shouldn't. I will trust Mr. Bender to work with the press to arrange the courtroom and the overflow room in accordance with the rules I will set forth here and anything else that may come up that needs my attention.
Wow. Wow.
I think that covers it at the present time. So the first thing I'd like to do is to get some clarity from the attorneys as to what furthermore, for the parties, as to what furthermore needs to be discussed. And then after that, we'll explore with the attorneys for the jurors and the attorney for Clerk Hill, any other issues that still need to be developed. Mr. Hopkins.
The clerk is going to hear from the two lawyers about anything else that might be needed for the hearing, and then going to hear from the attorney for the jurors. I don't know if there are multiple attorneys for the jurors in the audience. I know Eric Bland is there because I could see him. And then for the attorney for Clerk Hill, Justin Bamberg. So he should be there as well. Y'all, wild.
Please support, Your Honor. I'm trying to make sure I understand what you just ruled. Are you ruling that we cannot call the alternate juror?
Yes.
Or the so-called egg lady?
Yes.
To corroborate
Yes.
what was said to the sitting jurors, since they were all told
Yes.
this at the same time?
That's exactly what she said. Yep. Affirmative, Ghost
I'm
Rider.
not sure I understand your question, but I'm telling you that I want these jurors, these alternates would be called apparently to testify as to what the clerk said.
Yes.
At the present time, I see no necessity for them to be called to say what the clerk said, because we're talking about what the clerk said to the remaining jurors.
To impact the verdict.
Those
They
who
didn't
actually
deliver.
sat on the case.
The jurors.
The corroboration is something I don't think I need at this time. I think I'm perfectly capable of evaluating what the jurors tell me. And I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors for that matter.
Well, Your Honor, for us to
As I just said, Poot, I am perfectly capable of assessing the credibility of the witnesses. Poot's going to go in again. He's going to go in again. She's going to per my last email this shit, but he's going to try. He's going to try again.
and then you said you wouldn't allow a proffer of that except in writing. Now,
Yes, I'm not going to have a courtroom proffer of any kind.
You can write it down, Poot.
I'm going, if you want to proffer,
Written.
what would be offered by
Proffer.
means of affidavits, copies of emails, anything else you want to, that's fine. But I am not going to have a courtroom proffer, no. I think the only reason for the proffer would be to preserve your right to appeal. I believe your right to appeal, my rulings would be perfectly preserved, frankly, even if you didn't have a proffer.
Says the former Chief Justice of the Supreme Court. If anyone's going to tell you how your appellate rights are reserved, it is the head of the top court in the state. She's like, you're going to be fine with a written proffer, Poot.
But even more so if you supply an in-writing proffer.
well, I'm trying to determine whether an affidavit is sufficient for an appellate court, federal or state.
She wants a proffer.
When the
She didn't
state
say
will have an
affidavit.
opportunity
She
to
said
examine
written
that.
proffer.
But I mean, they've given, I mean, we can get more detailed affidavits.
Poot, affidavit and proffer are not synonymous. You might attach an affidavit as an exhibit to your written proffer, but it's not a proffer.
You know, these people are witnesses to what the clerk said to the juror who deliberated. I don't understand how that can't be relevant to Your Honor's decision. I understand there's two steps. One, did she make the statement? And two, was it prejudicial? These witnesses corroborate she made the statement.
Well, of course, that's what you say. So far, I haven't seen any of it.
Of course, that's what you say. Your Honor! I'm living. I cannot wait for the hearing on the 29th. I am here.
That. If that's what you say and you offer it to me in some form that I can evaluate it, I may revisit that decision. At the present time,
Okay.
But at the present time, I see nothing that prompts me to think I need to have people who did not sit on the case talk about what they think the clerk said to other people, when I've got to direct people to who it said that I will question.
Well, Your Honor, we did submit an affidavit, but I have no problems going back.
You submitted one alternate affidavit
Right.
and one affidavit of a dismissed alternate. I'm aware of that.
Right.
Uh-huh.
So.
Uh-huh.
And that doesn't prompt me to change what I've just said to you.
She
Well,
said-
we can get you more.
She doesn't want more, Poot. She said what she said. She doesn't want any more. She wants to call the sitting jurors. Poot, you're going to lose on this point. Just stop while you're ahead. Submit the proffer, preserve your rights, and move on. There are other matters to talk about.
A more specific, I understand what the questions are you have, and I would only put those folks up to deal with those very limited issues that you described. Put them up in 10 minutes.
No,
Again,
no, you're not going to put them up anywhere, Poot. You're not putting anyone else on the stand. She said 3 times that you can only call the jurors who deliberated, and all of them will be called. It doesn't matter what the alternates said. Their verdict was not impacted because they didn't render a verdict. That's it. Look, I don't understand. You have asked the same thing 7 times, Poot. She said no. Yes, chat, stop trying to make fetch happen. It's not going to happen, Poot.
I'm not going to rule in a vacuum. I'll see what you say, and I'll rule upon it.
We'll get affidavits and file them with the court.
Very good.
She
Thank
said do a proffer. What part of do a proffer means I'll get affidavits and file them with the court? Submit a proffer. Just do what the woman said. Ugh.
Your Honor, just one issue as to logistics. Obviously, these jurors are down in Colleton County, and we're up here in Richland County. I've spoken with SLED, and in as much as we need, there may be jurors who need transport. SLED has certainly agreed to have 12 cars if we need to make sure that they're individual. They can then come in through the garage, and obviously they'd be brought up to a jury room. I think Your Honor indicated they can be in a jury room with a bailiff in there to make sure that no one's talking about their testimony and that sort of thing, but also so that they don't have to come in through the public entrance and that sort of thing. So that would be.
I think that would be a good solution, and of course, to satisfy the concerns that the defense may have, you could either have
Snow is
a member
bright.
of the defense team or one of their employees ride with them, or if you could agree upon a sworn statement by the agent.
The jurors are getting in a Sprinter van, and we now have a full Bravo crossover.
Or a person that does drive them, that they, A, will not say anything, and B, did not say anything, then that may clear the problem too. I think you all can work that out. But I do think having proper transport would, first of all, be a comfort to the witnesses themselves, the jurors themselves. But if they can arrange something otherwise, of course, they'd be free to do that. But to the extent it's a burden on them, yes, I think that's a good idea. And in all events, I would want arrangements to be made to have the jurors come to the parking garage in this building and be escorted up in a private way into their assembly room.
And yeah, absolutely, Your Honor, and we will, and I'm sure SLED, I've already spoken with them about that, have uninvolved agents who will be under strict instructions not to discuss the case, and happy to have them sign affidavits or whatever to that
Very
effect.
good.
Logistics.
All right, anything further?
The judge said, talk to me about logistics. And Creighton Waters said, these are the logistics.
Go to the lawyers for the jurors. All right.
Your Honor, only one other point, and that is you've asked us to give you exhibits
Sir, you should have brought it up when it was your turn to talk.
that we will use.
Yes, sir.
Having not asked or had the opportunity to ask Ms. Hill a single question, I can't tell you, in terms of, there's not thousands of emails we've used, probably 5.
I'm just going on some of the descriptions that were in the filings y'all have made to me.
He's going on what you
We've received
said.
thousands of emails from Colleton County based on a subpoena we issued. We've received hundreds of pages from the AG's office and from SWED.
It'll make it a lot simpler if it's a small number and a discrete number, submitting them to me. Again, I told you I would evaluate that when I get it.
She's going to rule on it when it comes up, not in advance.
Of course, I don't think you can evaluate them until she testifies. You don't
I think you're going to have to trust that I am going to do some evaluating before she testifies.
Okay, and Your Honor, you know, she's given an affidavit denying making any of these statements.
She has.
So these alternate jurors that have been dismissed, would you allow us to call them to impeach her if that's what she testifies to?
At the present time, the answer to that is no, as I have indicated. But again, I'm not going to rule in the vacuum. I would hope that what you all will do is send me a pretty specific idea of what you want and how you want me to permit it. So I'm not going to rule on something I haven't seen yet, which is your proposal as to exactly how these witnesses and alternates can be used.
All right, we'll get more extensive affidavits from those two alternates.
Oh, okay.
Oh my God. You know what this judge never said she wanted once, never at all, not even a little bit, was more extensive affidavits from the alternate jurors. Never once was that the solution to the problem. You are trying so hard. But if the alternate jurors are the only ones that say that there was improper contact with the jury, it's not going to fly. They didn't deliberate. And that is why Poot is fighting so hard to have the alternate jurors heard. If 12 members of the jury come in and say, Ms. Becky told us to pay attention every day before court, that's not going to get you a new trial. Poot is fighting like hell to try to have the court consider the alternate jurors. And the court has reiterated over and over and over, no, I am not considering them. Because you know what doesn't matter? What the alternates think. You know why? Because they didn't deliberate. So jurors that may or may not have beef with this whole thing because they got booted off the case are not relevant. Oh, and I didn't realize how important this was to Poot's case until he brought it up 3-4 more times. Each time he comes back to this point, I'll get more affidavits, I'll get more of this. It's not going to change this judge's mind, Poot. You have lost on this point. If the alternates are all you've got, you are not getting your new trial. That is all, because those alternates are not going to come in. You can preserve it for appeals, but those alternates are not going to be testifying at this hearing. She has made it so clear. So clear. Oh boy. Oh boy.
That's fine, or descriptors of some sort from you as to what you intend to do. I'm not going to dictate how you do it, but I'm going to have.
You go ahead and do what you're going to do, sweetie. Bless your heart. You can go ahead and file those as proffers, like I said before, per my last ruling, 5, 10, whatever minutes ago. You can go ahead and do what you're going to do. What I'm not going to do is let them testify.
I have a lot more than just kind of the generalities that have been discussed in these briefs in order to permit.
Well, I think we're going to need an affidavit for appellate purposes, nothing else. I mean, my description to you is not evidence.
Oh, I agree. But, you know, again, I will tell you how I'm going to accept the proffer.
Round
what you
and
put
around
in the written proffer is up to
and
you.
around.
I don't want to dictate that or manage it.
Well, I just want to say that we're going to hopefully be able to get affidavits from these folks.
Yes.
Much more descriptive than the original affidavit.
Good luck.
Thank you.
All right.
Your Honor, may I consult with counsel very briefly?
Certainly.
Creighton is consultant counsel. We got a little bit frozen here on the feed, but the audio's good, so we're staying here. Yeah, Poot really wants that to happen. So hopefully the freezing is tough, but the audio's good. So there we go. Back to Creighton. Look, I am very, very sensitive to how difficult it is to get these feeds out of a court and how hard it is to get reception, to feed these out over reception. So I am appreciative that we have a clean feed to use. Even with the freezing, the audio sounds good to me. So let's see what Creighton has to say, and then we'll go from there. Poot needs an intervention for his addiction to the spotlight.
One of the things that was discussed earlier was the independent SLED investigation that was done. There were recordings of some of these interviews and MOIs prepared that were just meant to be summaries. I know Your Honor mentioned earlier that you would be open to receiving those. I just
I'd be glad to review that.
discussed that with counsel, and I believe they said, well, we want to send the ones we want to send. I think if Your Honor's amenable to that, we would just add Your Honor to the discovery upload that was provided to the defense so that information is available to the court for whatever purposes the court deems necessary.
Can I ask this?
Yes, ma'am.
First, would that discovery upload include?
All right, we're gonna switch. Let's see if we can. How far behind are we? We're just on Creighton starting to talk. We're a little bit behind real time because I've been pausing so we don't miss anything. But let's see. Give me 1 second to see if we can pull the WTLX feed. So thank you for the input, David and Team Luna Shark. Let's see if we can find our place and see if we've got a little bit better feed. Again, these are not easy technological problems to solve. We're just going to go back to the beginning of Creighton Waters speaking, which, let's see, the end of Poot, beginning of Creighton, and that'll, oh gosh.
Your Honor, just
Here's the issue.
Logistics.
And they have mono audio. Nothing is going to be perfect. All right, we're going to go to a different feed real quick and from WTLX 19. But keep in mind, if you're wearing headphones, their audio is mostly mono. So it's like 601, half dozen of the other. But let's boost this and hope for the best. Alrighty. Let's roll, law nerds.
Obviously, these jurors are down in Colleton County, and
Okay, we've already done this part.
Richland County. I've spoken with SLED.
Logistics.
Okay, and Your Honor, she's given an affidavit denying making any of these statements.
She has.
So these alternate jurors that have been dismissed, would you allow us to call them to impeach her if that's what she testifies to?
At the present time, the answer to that is no, as I have indicated. But again, I'm not going to rule in the vacuum. I would hope that what you all will do is send me a pretty specific idea of what you want and how you want me to permit it. So I'm not going to rule on something I haven't seen yet, which is your proposal as to exactly how
Which is fair.
And alternates to be used.
All right, we'll get more extensive affidavits from those two alternates.
Oh, okay. That's fine, or descriptors of some sort from you as to what you intend to do. I'm not going to dictate how you do it, but I'm going to have a lot more than just kind of the generalities that have been discussed in these briefs in order to permit.
Well, I think we're going to need an affidavit for appellate purposes, nothing else. I mean, my description to you is not evidence.
Oh, I agree. But, again, I will tell you how I'm going to accept the proffer. What you put in the written proffer is up to you. I don't want to dictate that or manage it.
Well, I just want to say we're going to hopefully be able to get affidavits from these folks.
Yes.
Much more descriptive than the original affidavit.
Oh.
Thank you.
She's like, do what you want, dude.
Your Honor, may I consult with counsel very briefly?
She's not going to tell you. All right. We're back to Creighton, and this is catching up to where we were a moment ago. Vicky in the chat said, I'm loving and miss court cases with you, Emily. I missed it
One of the things
too.
that was discussed earlier was the independent SLED investigation that was done. There were recordings of some of these interviews and MOIs prepared, and they were just meant to be summaries. I know Your Honor mentioned earlier that you would be open to receiving those.
Sure, I'd be glad to review that.
Discussed that with counsel, and I believe they said, well, we want to send the ones we want to send. I think if Your Honor's amenable to that, we would just.
If you're interviewing all of the jurors, you send all of the interviews from SLED of the jurors.
Add Your Honor to the discovery upload that was provided to the defense so that information is available to the court for whatever purposes the court deems necessary.
Can I ask this?
Yes, ma'am.
First, would that discovery upload include your interviews, the tape of the interviews, as well as your summary of them?
Yes, ma'am.
All right. I will ask you to let my clerk, Eva Diaz, talk with you afterwards about how to send me something of that volume.
Sure.
Our court IT has a lot of barriers in our system to us receiving even conventional websites and web tools for examining in volume documents. And so I will want her to interact with you all about exactly how I am to receive that material. But yes, I would be happy to receive it.
And we would be happy to get a couple of flash drives and provide it that way.
That might be
And
easier.
that might be the better way to do it.
That might be easier.
Again, I can very easily examine a flash drive, even though it takes a long time, particularly if you are kind enough to provide an index at the front of the flash drive as to where the various materials are located. That might be better than using one of these web document sources, since so many of them are excluded from our system.
Right. Well, we'll prepare one. And
The
have a
government
copy for,
computers are
you,
saying,
for,
nah,
Ms.
do
Diaz.
not send me,
Thanks.
do not send me video.
Now, on my list, I have in the courtrooms this time, Mr. Bland, who represents certain of the jurors, Mr. McCulloch, who represents certain of the jurors, and Mr. Lewis, who represents Ms. Hill. Are there others in the courtroom who represent jurors or Ms. Hill?
Well, Your Honor, Ronnie Richter, on the Earth Claims partner.
Well, a little fast for me.
Ronnie Richter,
Oh,
Mr. Claims partner.
right.
She meant anybody else.
Any others?
That's what
All
she
right. Well, then we'll begin with you, Mr. Bland, if you and Mr. Richter would come forward.
All right. The judge had previously said, and the defense had previously argued, that the lawyers representing jurors have no place at the hearing. It's interesting that she's giving them an opportunity to be heard, whether or not these jurors want to be subpoenaed. Let's see what happens. I think the judge is just giving an opportunity to make sure there's no complaints later
For jurors
about her not being fair.
I would like their numbers, but only if that doesn't violate the attorney-client privilege. And you gotta give them to me now or later.
Can I give it to you later? I have them now. Our job is we want to preserve their anonymity.
I understand.
2, we want to make sure that they're not harassed. And 3, we want to make sure that the verdicts of their conscience remain. And that
I mean, they're not going to be harassed by the attorneys because the judge is going to ask the questions. Shouldn't be harassed by the internet because they're just doing their jury duty. And we'll see what else Eric has to say.
is not only because they voted guilty, if they voted not guilty, we would feel the same way. After hearing what Your Honor has established by the way of procedure.
Let's just be clear. If they voted not guilty, none of us would be here. If Alec Murdaugh hadn't been convicted, none of this would be happening. The double jeopardy would apply. The state has no right to appeal. Like, it would be done. The only reason we're here is because they voted guilty, but okay.
We're very comfortable with what you have established to protect their anonymity and
Great.
they're not harassed. Ronnie came up with a good suggestion. Maybe you renumber the jurors 1 through 12. And that way, because there has been some public disclosure
Sir, that's going to be real confusing because their affidavits are under their juror numbers. I'm just saying.
of the jurors' numbers in some of those emails, they were the big batch of emails that are written reference. So maybe we cross-reference with a chart 1 through 12 in the juror numbers. But as far as the questioning goes, there's no need for us to be part of this.
I was frustrated that the FOIA dump that was made public did have so much juror information in it. As I've been going through those emails, I've been redacting it. So when I pull it up, but none of it was redacted out when that was shared publicly. So I understand what he's talking about.
You're going to make the questions. You indicated that you're going to preserve their anonymity, that they can't be photographed, they can't be on videotape, and that's about all we have to add.
That's about all you can do.
Yeah, Your Honor, I would amplify that I certainly respect and appreciate the significance of the issues that are before you. And I respect your decision that you're going to make this public.
I have never seen lawyers get to just kind of stump like this in a court. She's just giving them all the room in the world to just say what they have to say, which is kind.
I would have asked you to make the jury portion closed courtroom. And Your Honor, only for this reason.
Sir, the
The trial was public. Those jurors have been seen during the 6+ weeks of trial. Some of them have gone on television. I mean, it shouldn't be closed courtroom. I disagree.
That I don't know what the
Hard
judge would
pass.
say, I don't know what you're gonna rule, but let's just say in a hypothetical.
She said it
setting
should be public.
That because juror number 9 said something that you believe deprived Mr. Murdaugh of his right to a fair trial, you're going to grant a fair trial, a new trial. I would hate for there to be any mechanism for somebody to backtrace to who was juror number 9. Because the public has very firm opinions about this matter, and I wouldn't want that person to be subject to any kind of public scrutiny. So I would
That's
ask
fair.
you that for the juror portion, it would be closed courtroom, that the press would be present, that their likeness, both voice and face, be muddled, just as an additional safeguard. But I certainly appreciate what the safeguards you have put in place. I respect your ruling. I just throw that out for consideration. And on a broader perspective, I know that you've had this experience as well, Your Honor. It's becoming more and more difficult in this state to see the jury. And I can't think of anything more injurious to jury service on a broader perspective than to see, jurors
Them
who
ripped
have
apart on
6 weeks of
Reddit.
their lives being pulled back in for a process like this, as necessary as it is. So I worry that the process be handled as gingerly as possible, so as not to further.
That's a
prejudice
very
our
fair
ability to get
concern.
juries going forward.
I think it's a very fair concern.
Thank you, sir. What I will do is.
Because I think a lot of you are like, why the hell would I want to serve on a jury, especially of a high profile case, if this is the mess that I am going to have to deal with afterwards? I understand the concern. It is a very, very real concern that people are going to find every way not to be on jury duty. And no, I don't think I don't necessarily think the jurors have to be on camera. I think audio is fine. I think that's up to the court, but I don't think it needs to be a closed courtroom. I think it needs to be a public courtroom.
I think your suggestion of renumbering is a good one. It's something that my clerk and I had talked about between the two of us as well.
Okay.
In every proceeding I've ever seen where a juror was questioned, in every case I've read where jurors were questioned because of allegations either during trial or post-trial that they had been tampered with, those proceedings have been in open court.
Yes.
And I don't feel it would be appropriate for me to have some kind of in-camera proceeding, even if it included the attorneys that would have to, and even if it included members of the press but not the general public. I don't think
It has to be an open
that is in keeping with the public nature of trials in this state and the public nature of court proceedings.
Agreed.
However, I think we could make some protective arrangements for when they testify and their ability to be dismissed after they testify that would protect them from being self-prone to the best extent possible.
It's also hard because locally people are going to know who these jurors were. They live in a very small county. They live in a small location and they all missed work for 6 weeks. Like the ones that didn't go on TV, I think people will still figure out who they were. It's like, oh, I was sitting on a jury. It's like, well, there was only the one going on at the time. So it's more to protect them really from people being assholes on the internet, which is a unfortunate thing that there's this push-pull because the internets, but also the internet tries to intercede in high-profile cases beyond the bounds of what would happen maybe just locally, just because the scale is greater. So I understand the concern here.
So that is the way I will handle it, and I hope all things on balance that
Audio
that
only.
is,
I think
is
it's fair.
protected as you think it needs to be.
We trust you, Your Honor.
All right.
Your Honor.
Oh, chat. I thirst responsibly, chat.
Their service of the subpoena so that they don't have to be
Well,
served.
that's great, and of course you don't represent all of them.
No, R4.
You're full, but that's great, and it may very well be that these parties are going to be able to work out something with respect
That's
to
fair.
some of the rest of them. I don't know, but
While I was talking about thirsting responsibly, what Eric Bland said is we will accept service for our For Jurors. accepting service of process is a huge part of tomorrow's podcast, talking about Scientology and David Miscavige. But he said, don't go out to their houses. We will accept service for them. And the other lawyer will probably do the same. So we'll see.
Appreciate that on behalf of what you represent.
Do you want me to come up and tell you our juror numbers?
Not at the moment.
No, sir.
Give it to the clerk.
I don't need that this moment.
Thank you.
Thank you, Judge.
Yes, sir. Mr. McCulloch?
With all things, thirst responsibly. Bland is representing sitting jurors.
Go to the podium if you would, please.
This is Mr. McCulloch, who represents some of the other jurors, who also hosted a birthday party for Becky Boo from the court, from the block, which I saw in the emails. Oh, I paused. I've gone too far. There we go.
Your Honor, I believe by some of your rulings today, they've satisfied several of the things I was going to mention. One, Your Honor, was, of course...
How many jurors do you represent?
I'm sorry, Your Honor, I represent number 785 and 630.
So the two?
Was a deliberating juror, I suppose we could call her, and the other was the
One alternate.
removed juror.
So he represents Egg Lady and one other juror. Sir, let me just communication. When the judge asks, how many jurors do you represent? The answer is 1 or 2 or 3. Not, I represent this juror and this alternate juror. Answer the question that's asked and it will all go so much faster.
Now, with respect to the replaced juror, I think my ruling about the end of any testimony from that juror satisfies any requirements you've made. I believe that I will not hear testimony from that juror, alternate juror at the present time. Now, Mr. Harpootlian is going to submit additional information. As regards your client, I'd ask you to submit that information to me as well. And then I'll see if there's any revision of the position I take about that. You also represent one sitting juror, so you may continue.
Your Honor, the other juror was not an alternate. She was an actual seated juror.
That's it.
We get it. It's the Egg Lady. We know. It's interesting because now we've spent I keep pausing and making it worse, but we've spent all this time going back and forth when the question was, how many jurors do you represent? And the answer was 1.
The sitting juror.
It was removed at the end of the trial.
Oh,
Practical questions. Whoops.
I need Mr. McCulloch to speak up, please.
you need to speak up some, Mr. McCulloch.
I don't get that much, Your Honor. Your Honor, if you will indulge me just a moment, I think much of what you said today bears on a quote that I'm taking from the response of the state, which was filed and was part of your record. And my letter of November 10th responding to that filing is also a part of the record. But the state said that jury duty is this cornerstone of civic duty. Needless exposure to the jurors to litigative stress and impeachment by zealous attorneys in a case especially of this public exposure can only serve to discourage citizens from willingly participating in a jury.
Wait, is he arguing that the jurors shouldn't be questioned at all? Because I think that's what he's arguing.
In this civic duty.
Okay.
I'm delighted with your ruling that you'll be asking questions. I've been subject to your interrogative skills in my appearances before the Supreme Court.
Okay.
So I'm pleased with that, and I checked that off the list. I would like, Your Honor, for you to take judicial notice that there have been excessive public comments by, and I have to say, Your Honor, in my letter of November 10th, I took Mr. Waters, who signed the letter, to task for labeling one of my clients, one of these jurors, as dishonest. I think I wasn't pleased with that. I think that discourages civic participation. I would ask the court to admonish the litigants.
Your Honor, I would like the court to tell them that the rumors and the nastiness cannot go forth as to my jurors. Sir, this is just not the place.
Mr. McCulloch, let me stop you there. I am not aware of
Thank you,
any of what
Justice
you're talking
Toal.
about in terms of comments about the jurors or otherwise. So that's just not something I'm gonna take into account by listening to it or by taking any judicial notice of it. I don't know what I would be taking judicial notice
She's like,
of.
miss me with all of it.
I do not know anything about what you're talking about.
You're on both my letter and the response
She just said, miss me with the gossip.
of the state are part of the record, which you obviously have not gotten to, but I would assume yet. My only request is I would admonish lawyers, officers of the court in this courtroom and outside of this courtroom who represent people to be cautioned that this is a search for the truth, not an effort to protect the verdict, nor an effort to discourage people from participation. A negative commentary does that, or runs the risk of doing that. That's all I'm saying.
I understand, and I decline to instruct or admonish participants in this procedure in any way about what you say.
Thank you.
Okay.
Your Honor, next, I like Mr. Ricker and Mr. Bland. Appreciate your efforts. I suspect that we will decline a ride to the courthouse, but I would ask the court to consider allowing the jurors who choose not to ride with SLED agents to be permitted an entry and exit from the courthouse that would involve or relieve them of the necessity of coming through the front door.
I think I've already said that I will make arrangements for juror witnesses to report to the basement where the law enforcement station is, and there will be a code that will be directed to the assembly room.
And Your Honor, lastly, I think, if I understand your rulings or discussions about what process will occur here, this may run at odds with it, and I'm not arguing with you, Your Honor, you know best.
What is it then?
I am
Respectful
of the
disagreement.
belief That this litigative stress that I earlier referenced could be avoided, and the public and the media not denied their opportunity to gain access and knowledge of the proceedings by not exposing these jurors to a crowded gallery, a full gallery of press, by allowing its recording through, I understand, court TV will be the pull camera. That is to say that I have actually, in my history, participated in proceedings that involved the questioning of jurors, which was done in camera. So I don't think it's without any precedent, but I would.
It has to be an open court in this case, sir.
To consider, or
It just
reconsider
has to.
that no damage would be done to the right of the public to know and participate in the proceedings, but you can accomplish the same thing by allowing the pool camera and avoid the distraction and the imposition of that on these jurors.
They sat in a trial with a crowded gallery for 7 weeks.
I hear what you're saying, and I'm not inclined to.
She is disinclined to acquiesce to your request.
But, I'll keep an open mind about it as we make pre-trial preparations for the hearing. At the present time, the jurors will be examined in the courtroom, as I have indicated, with appropriate identity protection.
Thank you, Your Honor. And subject to your rulings, I will have both of my clients.
Okay.
For these parties as they might be needed.
Only one of your
subject to
clients is
approval.
subpoenaed, sir.
Thank you.
Your Honor, do you expect all jurors to be present for all 3 days?
So, let me make it very clear
Yes.
that I expect the jurors will be the first witnesses to be called in
Yes.
these proceedings. And
That should only take a
jurors
day.
will testify, and then they would be dismissed. They would not.
That should only take a day, because the questions for the jurors is, did the clerk of court talk to you about this case? Yes. What was said? No. Okay, move on. That's it. It's going to be very quick as to the jurors.
Be required to stay for the rest of the proceedings at all. So that is very much a part of my thought about what it takes to protect their identities. They would be protected as best I can, and the ability of others to come and to set them with questions as they leave would be protected. So,
Do you expect that you could get through all 12 in one day?
Yes.
Or should I tell them, because a couple have to take off for work?
yes, I do.
Okay, thank you.
And Mr. Lewis.
Who represents Becky Hill.
Your Honor, I'll be brief. In light of your rulings, I don't think you need much from me. The only thing that I'll add is I'll have Ms. Hill available for here as the parties need them, and happy to accept service to alleviate one issue for this court. Unless you need anything from me, Your Honor.
Well, Mr. Lewis, you might be our favorite, sir. Ma'am, you've got this handled. My client will be available. I'm happy to accept service. Thanks, Mr. Lewis. That's what we like to see.
All right, thank you for that.
We like the tie.
Before you leave the podium, let me just consult with other lawyers. I'm not going to ask them to examine you, that wouldn't be fair at all, but I'm going to ask them if there's anything else I need to inquire of.
That was
before
funny.
I let you go. Because I understand the subpoena, and we would have a formal subpoena of Ms. Hill would be placed in your hands as her attorney. And you would assure her appearance, and I appreciate that very much.
Absolutely.
Is there anything else on behalf of Mr. Murdaugh?
Your Honor, just in an effort to try to expedite this matter, I have two questions. One, will Ms. Hill meet
Hoot!
with Mr.
Nothing you do has expedited shit. Your Honor, in an effort to expedite, let me talk to you for 5 minutes. This is Becky Boo's lawyer, Mr. Lewis. Becky Boo might have two lawyers because Justin Bamberg responded. I don't know if they work for the same law firm, but this is Mr. Lewis is Becky's lawyer for this proceeding. So she might have multiple lawyers for different things, but Poot, let me, in an effort to expedite this, let's muddy the water. Great. Okay, Poot, let's go. Let's see what you have to say. Maybe it'll help.
Griffin and I?
We'll evaluate that.
You'll evaluate it. Okay, that's all I can ask. And secondly, should we?
Damn it, Emily, you talk too much, and now you need to hear the beginning of his sentence again. Sorry. It's on me.
On behalf of Mr. Murdaugh?
Your Honor, just in an effort to try to expedite this matter, I have two questions. One, will Ms. Hill meet with Mr. Griffin and I?
We'll evaluate that.
You'll evaluate.
He asked, will Ms. Hill meet with Mr. Griffin and I? His response was, we'll evaluate that, because he can't say fuck no without consulting with his client first. We'll evaluate that. That's not going to happen.
Evaluate it. Okay, that's all I can ask. And secondly, should we have her here on that Monday or wait? I mean, if you're going to be doing the jurors most of all
She
day.
should be here as court reveals.
All right. Thank you. Nothing from the state, Your Honor.
All right.
Thank you, Your Honor.
Text, but I think, can we bring in a lady juror? Please.
I'll go over my checklist one more time, but I think I've covered everything I want to cover. I'll come to each of you in a moment. Yes, just to clarify other witnesses, as matters now stand, the witnesses in this proceeding would be jurors and Ms. Hill. All right, so I want to be sure that we're all understanding exactly what's going on in that regard. I would not allow the attorneys to be called. I'm unclear about the mention in some of the papers that SLED investigators would be asked to testify, or any other witnesses. So I'm going to go one more time. I want to get real specific so you will understand what you need to prepare for by way of in-court examination and what you need to prepare for by way of submitting proper. All right, first of all, for the defendant.
Police Court, Your Honor, just a couple of issues. One, we don't know who we're going to call to impeach Ms. Hill. Because we don't know what she's going to say. So it's difficult for us. I mean,
the court will decide if you're allowed to impeach her when it happens.
Once she testifies, at that point, we say we'd like to call so-and-so and so-and-so and such and such and such and such, number one. Or maybe no one. I mean, she may concede every issue we have. For instance, she did tell, according to the state, she did tell one of her assistants, one of the people helping her, I hope he's found guilty because it'll help book sales. Now,
I hope that's the last time you're going to repeat that until I ask for it again, Mr. Harpoon.
Oh my God, Justice Toal. I hope that is the last time you're going to repeat that until I ask for it again. Oh, it's so good with the Southern accent. It's so good. I'm dying. We're going to do that. We're going to run that back again. This is the best shut up and sit down I've seen a judge deliver in a long time. Oh my God. Justice Toal, get it. All right. We're going to just live that moment again and I'm going to shut up.
So it's difficult for us. I mean, when she testifies, at that point, we say we'd like to call so-and-so and so-and-so and such and such and such and such, number one. Or maybe no one. I mean, she may concede every issue we have. For instance, she did tell, according to the state, she did tell one of her assistants, one of the people helping her, I hope he's found guilty because it'll help book sales. Now,
I hope that's the last time you're going to repeat that until I ask for it again, Mr. Harpoon. I've told you that I can't imagine a situation in which I would go that far. So, a statement like that, and she may well have said it, if it goes to anything I'm asked to consider, it would be to her credibility. And I'll evaluate whether I think that's even proper to ask, but let's move on from that.
but there are other questions concerning her credibility.
Yes, sir.
404.
And she has said she will get to that when she gets to that. That was delightful. Oh, spicy. This judge is going to be spicy. I'm here for it. Between the spice, like the velvet shade and the delightful Southern accent, I am so here for this hearing and so excited for it.
Motive for if she did this, it is a crime. And
which is why she would plead the fifth.
The questions of why she would have done this extraordinary act, and we can argue this at another time, but in terms of me the reason I mention it is for us to proffer those people now, not knowing what she may admit, that question may get asked, she may admit it. There's no witness that needs to be called. So it's difficult for me to game this out. I don't think I've ever been asked to list witnesses I would call to impeach somebody if they lie under oath.
Sir, you're bearing the burden of proof, so you gotta let the judge know who you might call.
I've never heard of such a thing, but I will attempt to do
Okay.
the witnesses we would call prior to Ms. Hill's testimony. That's all I think I can do, if that makes sense.
It doesn't make complete sense to me because this is not the trial of Ms. Hill. And issues about motive and so forth and possible commission of crimes are not what this inquiry is about. It is about her contact with any juror and what she said. So I will be treading very carefully with the deal of what you say about what you might or might not ask. But I am going to ask all the parties to be pretty specific with me about what I should be asking the jurors, and I can make a decision in advance as to what I am going to do about that, and what is going to be, at least by general topic, pursued with witnesses.
Yes, sir.
And the reason I do that is because it gives me the opportunity to then consider what rulings I would make and move the proceedings along in an orderly way.
Well, you're right, maybe premature.
Ma'am, you've met Poot. I know that you are trying to do this in a linear, orderly, and quick fashion. He is extreporous, but I really, really like that she's not afraid to just jump in. Judge, Newman would often let them finish and then make his remarks. I love that she just jumps in and is like, I really hope you're about done with that. I am so here for it. I am so here for
For
it.
me to note this for the record, we would accept your ruling on that.
All right.
Okay. Second,
You don't have a choice, Your Honor. We will accept your ruling. Or what? Or what? Or what? You would accept her ruling or what? You don't really have much of an option. But here's Justice Toal. Witnesses, name them. Name them. Name them. And Poot's like, blah, blah, blah. Name them. I'm waiting. Justice Toal, could you please just start telling Poot to name them over and over and over again? Please?
Mr. Murdaugh has been unable to review any of the discovered material in this case because of the confidentiality order prohibits us to distribute to him while he's in jail. We don't have time in the next
What you don't need is everybody's information floating around the jail. That's appropriate.
than 2 weeks to go sit down with him and review everything. Would Your Honor allow him to have, and the materials are not as to the evidence in the underlying case, it's as to jury issues. And while he is no longer a lawyer, he was a lawyer at one point and can evaluate this and be of assistance to us if he has an opportunity to review that material.
You're speaking to me about something in a complete vacuum as far as I'm concerned, so I can't really evaluate.
Can't help you, sir.
What you haven't been able to review with him and what you have been able to review with him. As I understand what you're telling me is, I have received certain.
She's like,
information
not my circus, not my
as
monkeys,
the attorney
with what he
for
can review.
Defendant, that I have not been able to show defendant or defendant's review because of the confidentiality order. I can't imagine that. I think what you may be saying is Mr. Murdoch has not been able to keep for himself, while I'm not there, confidential materials.
That's correct.
That is something common to many folks who are under incarceration and are limited in the kind of materials that they can receive and keep in their possession when they're not with their lawyer. This is not an issue where he's being deprived of the ability to consider material that you have received. This is a question of whether he can have that material in his possession when you are not there, or
Right.
your representatives are not there.
Go to the jail, Poot.
And so forth. I can't control what the limitations of the Department of Corrections are, nor can I control what limitations may have been put on confidential material because of the fear that it would fall into other hands.
Right,
So
go to the
I'm
jail.
not going to rule in the abstract on things. I would have to have something that's pretty specific, but I can tell you this. I would certainly not order that these materials be wholesale given to
Stephen,
him
I agree.
to take back to his cell and have in his possession, because I don't know who might see them were that the case. And if they are confidential materials, that would be an extreme risk of breaching the confidentiality of materials to do that because of his situation. And his situation is as it is, not my making or yours.
Your Honor, I would only note for the record.
This is a situation not of my making or of yours. He is in jail. Even if you discount the murders, he is in custody for 27 years on all the financial crimes that he pled to. He is in custody. You can go there with the documents and review them. Barbara can go. Jim can go. You've got a flying fucking fleet of lawyers. Someone can go sit with him and review these. You've got a team of like 7. I realize that's not maybe how you want to spend your time, but he doesn't get to just sit and review them on his own. And, that's just the way it is. That's just the way it is. All right, let's keep rolling.
After this, much of the material we've received has been within the last 2 weeks. This hearing is scheduled for 2 weeks from yesterday.
And
and you've given us more stuff we have to do between now and that hearing.
Your Honor, you've given us more shit to do, and I don't know how we're going to be prepared for this hearing that we've been asking for since September, sir.
There's nobody to go sit with him at the jail, and his time is limited as to when those people can visit. So without him being able to review this material, I don't think we can be effective. And we would be ineffective in representing him.
Well, I understand that those are wise statements for an attorney to make to preserve your position on the record. It doesn't change my view of how we should proceed in this matter at all.
The judicial you do you boo-boo that just came flying out is so amazing. She's like, I understand that it's wise for you to put that on the record in your position. You do you. You're doing your job. You say what you have to say, but it's not going to change my mind one damn bit. I love this judge.
To preserve your position on the record. It doesn't change my view of how we should proceed in this matter at all. I think you will be able to, if there are deficits in what you have been able to do with your client, you will place those contentions on the record, and the appellate courts of the state will have adequate chance to review.
How do other lawyers visit their clients in jail? They go to the jail and they visit their clients in jail. It's literally a central part of being a defense attorney. They visit their clients where their clients are housed. And there are rules to do such, and that is what happens.
Continuing hearing on the 29th allow us to meet with the client to effectively review these materials?
No, sir. Thank you.
We respectfully accept your ruling.
I understand.
Thank you.
I am so annoyed. This lawyers in South Carolina, if this is a South Carolina local thing, let me know. If this is a Poot thing, let me know. I am open to feedback on this. But we respectfully accept your ruling is, to me, so passive aggressive. And I practiced in California, specifically Los Angeles. And generally when the judge ruled, we would say, thank you, and then sit down. Or not. You don't always thank a judge for their ruling. Sometimes you just sit down, which is hard because colloquially, you generally like to sign off on a sentence with a period and be like, thank you, Your Honor. But it feels so condescending and so underhanded. We graciously accept your ruling, as if you have something else to do but accept this judge's ruling. It just irks me. It irks me in a very passive aggressive way. And the thing that irks me even more is I didn't hear him do this once to Judge Newman. He would thank Judge Newman. He would say, thank you, Your Honor. But I didn't have him say or hear him say to Judge Newman even once, I accept your ruling, as if it's yours to accept. This is the way. This is a former Chief Justice of the Supreme Court. It is the way. It's not for you to accept or not accept. It just is not sitting well with me. I am irked. I'm letting you know that I am irked. If you guys heard it with Judge Newman at all, please let me know. But I remember him saying, thank you, Your Honor, to Judge Newman, and Judge Newman eventually saying, you don't need to thank me for my rulings in front of the jury, but never, I'll accept that. You have no choice but to accept. I don't like it at all. So you let me know. It feels patronizing to me. I might be particularly sensitive to it because there's times when old male attorneys just rub me the wrong way, and that is on me and the career that I have experienced. But it feels condescending, and I don't remember him seeing it. I don't remember seeing him do this to Judge Newman at all, because I would have commented then, it's not your ruling to accept, it just is the way. I don't like it. This is the way. Just, it riles me. So if this is colloquial to the region, someone just let me know. It might not be as rude as it reads to me, but it reads rude to me, and it pisses me off.
I don't have much to address, Your Honor. The initial question that Your Honor asked was about.
For all of you keeping a bingo card, this counts as I'll be brief. I don't have much to address is synonymous with I'll be brief. Put it on your bingo card.
About SLED agents being listed on the potential witnesses. And, again, Your Honor, when these allegations were first raised, we instructed SLED to do an independent investigation, good, bad, or ugly. And only because of the results of that investigation, or is the reason why we're standing here and litigating these issues before Your Honor. Ultimately, the only way that SLED agents could potentially be testifying, and again, when we filed our response, we didn't know exactly the parameters of the corporate rule. The only way, though, that I can see them potentially testifying is in the event that there is an accepted witness by Your Honor, that there was some sort of prior inconsistent statement under Rule 613 or some other permissible inquiry. But I think Your Honor's rulings as to the nature of the inquiry we're going to conduct would probably remove or make it very unlikely that need.
All right.
And it was brief.
Nothing from the state, Your Honor.
Nothing to defend, Your Honor.
All right. I say to attorneys for both sides, the court is deeply grateful for the very fine materials you have submitted so far. This an extreme amount of work in a very truncated period of time, and I appreciate the burdens it places upon you, Mr. Hopgood. I particularly thank you as a member of the General Assembly for not interposing your immunity because you are in session, and I respect that. I set these matters after consultation with y'all so that I could fulfill my obligations to the court as expressed in Chief Justice Beatty's order. But
I'm going to just interject and explain what the judge just said. The judge is thanking Dick Harpootlian. This doesn't happen in every state. Again, Dick Harpootlian is a member of the assembly, the state assembly. They are in session. Generally, lawyers who are part of the assembly have immunity for when they are in session. So what Poot could have said is, hey, I am in session. I have immunity. We can put this hearing when session breaks. So then whenever the end of this session term is, March, April, whatever, it would get put off to the break. He waived that and said, we will work on the judge's schedule. And she is acknowledging that, which I appreciate, because he has conceded to move this along. However, I imagine that Barber and Griffin are picking up some of the slack while he is in session. So that is why she is thanking him and acknowledging that he could have pushed this out to the end of session, but didn't. This doesn't happen in all jurisdictions. Where there are lots of jurisdictions where you don't have lawyers that are still practicing in court that are members of, like, active members of governing bodies. But it is what it is in South Carolina, and it is accepted within South Carolina that sitting members of the legislature are also practicing attorneys, and they've worked that out within their state. So I appreciate that she has noted that. I didn't even think about whether or not they were in session. It's just so foreign that, lawyers are also going out and working like their side job being legislators writing the law. It's old school, like 1700s old school. I pushed play.
I realize that I'm doing that with your extreme cooperation in light of your other duties, and I appreciate it very much.
Thank you, Your Honor.
I look forward to further submissions from the parties and from the hearings commencing January the 29th. Court will be in recess.
Thank you, Your Honor.
Court is in recess. So they were in session during the trial. They were in session during the trial because Alec did not waive for the murder trial. Oh.
I asked Ms. Harris.
Because Alec did not waive his speedy trial right for the murder trial. So let's hear what the judge has to say.
Before these matters commenced, to please expedite, even if it's in a rough form and not in a perfect form, the court would like to produce the transcript. I asked her to produce a rough copy of the transcript just as soon as she possibly could for both sides. I hope you all will consider, without me having to order it, sharing the expense of this production, this early production of the rough copy of this matter. She she will be in touch with you. You may be in touch with her with regard to the rough transcript of these proceedings. Or be in recess. Exactly right.
I appreciate that she's asking them to work together. I'm going to turn the volume down as court exits, and we're going to get to as many questions as we can. And then we'll get to questions. I'll give a summary as best we can as court's wrapping up, but I'm definitely going to turn this volume down because now it's just going to be background noise. We will get to questions and some of a summary, and then I have got to zoom, assuming that my flight is not canceled. You never know. Fingers crossed. Who knows where we will be later today? Will we still be in Tennessee? Will we be in Los Angeles? Who knows? Who's talking to Mr. Bland? I just want to see what court proceedings continue to happen. Shania says, I truly hope he doesn't get a new trial. Here's the thing for me. If the clerk engaged in jury tampering, he deserves a new trial. If that is a lot of hyperbole, he doesn't. I would rather, now that the question's been raised, we need to see it play out. And we need to see what happens. You can both have a guilty defendant and a defendant who deserves a new trial. Emily Outdoors, completely agree. That was more succinct than my last statement, but yes, completely agree. So you absolutely can. And I want to see the system get it right. We can't have people who are part of the court staff messing with jurors. So what is the date of the hearing? January 29th is the first date. I will be covering it here, gavel to gavel. Make sure you guys like and subscribe. A, first, do the YouTube things. But B, the Law Nerd app will keep you in the loop when I am streaming. When we know the time of that hearing, it'll probably also be 9:30 a.m. Eastern, 8:30 Central. When we have time of the hearing, I will be streaming gavel to gavel with a lunch break as needed, just like I did during the trials. So we're going to have a 3 or 4 day hearing that we're going to cover gavel to gavel here. I know a lot of you have missed that. I have missed that. This is the first one that's coming up that we're going to cover like that in the new year. So we'll be doing that. Make sure you sign up for free Law Nerd app, iOS, Android, and do the YouTube things. I appreciate it. I hope you don't have a plane. No, Misty, no. I checked my aircraft. We should be good. We should be good. Why wasn't she forced to retire like Judge Newman? I think I answered that a little bit earlier. There's the South Carolina Attorney General, Alan Wilson, who we saw during the Murdaugh trial as well. It's his office that's prosecuting Alec Murdaugh. So I'm not surprised he's there in the courtroom. The judges can come out of retirement to sit for special things. So she is retired, but she came to sit for this thing. Miss Tanisha said starting massage therapy classes tomorrow. Thank you, Emily, for inspiring me to continue my education. Miss Tanisha, congratulations. Law Nerd round of applause. We're going to keep getting to questions, and then I'm going to do a summary. Salty Beach Girl said, Emily, their grandfathers ran illegal moonshine together, talking about Alec Murdaugh and Miss Becky. Poot said he knew when it was happening in a news interview. That's going to be a big question in this case. Did the defense know that this was going on at or near the end of trial? And if they did, this might get yeeted just because they waited too long. That's possible. Question, didn't defense say they had suspicions during trial? And if they did, it will be brought up because the court has not closed the door on that question. Question, I'm all for a fair trial, but if he's going to spend life in prison anyways, isn't this just a waste of time and resources? I think it's a really fair question, but he's not necessarily going to spend the rest of his life in prison. We haven't had him being sentenced on the federal sentencing yet. He's gotten 27 years, but I think it's also about seeking justice for the victims and answering these questions of who killed Maggie and Paul. And so if he gets a new trial, will they choose to re-prosecute it? That is the question. I think that they will, just because the case A is so high profile and B so serious with it being a double homicide. So there's always a reason. He can't appeal the plea deal, but there's always a reason to continue to prosecute, and I think that they will. So I don't see it as a waste, but I can understand why put these counties and these jurors through this another time. I absolutely understand the sentiment. So Poot wants to help the judge ask questions. Yes. We're going to do a summary in a minute. Question, do we know how long it was since Jim and Poop first heard the allegations against Courthouse Becky? No, not definitively. We saw Jim Griffin say in an interview that it was right at the end of trial. So there might be a timing issue here. Will Poop pull shenanigans with Justin Toal? Chat with Justice Toal. Chat, go ahead and answer what you think. I think he tried. I think the shenanigans were shut down. That's the exact kind of binder I used to carry my case folders in, the one Creighton has. I had different colors so I could color coordinate them on my shelf, but that's exactly the accordion folder that I used for my cases too, because they were easy. Would love to chat about hostile witnesses. This was one of the things that came up because, there we go, and that is the end of the court feed. Because the defense said they would like to call Courthouse Becky as a hostile witness. What does that mean? It means a witness that you call that is treated as an opposing witness. So for Clerk of Court Becky Hill, if the defense called her for this hearing, then they would be not allowed to cross-examine her. They would be giving direct examination and following those rules of evidence. If she's deemed a hostile witness, then they can cross-examine her instead of direct examining her, even if she's called by them. So it's being able to treat a witness as if they are opposing you, even if they are called by you. That is what a hostile witness means. It means that they are essentially an opposing witness to you, not a witness called by you. Hopefully that makes sense. If Becky doesn't testify, what does that mean for the case? It means you're left with whatever information the jurors provide. And if all the jurors say she didn't talk to us about the case, the judge might not allow her to be called because this is about the juries. Is jury tampering a bit of a big jump from exaggeration and plagiarism, though? Yes, and the court has said she's not going to give a lot of credence to those areas, and that sorry, I needed to move that on my desk, and that she's not giving a lot of credence to the things swirling around. She needs to wait to see what happens and wait to see the testimony and see whether the Fifth Amendment is pled and deal with it. The judge can't rule on what she's going to do in a vacuum. She said that over and over. You need the information in front of you, and then you can choose to rule. So before we finish questions, I'm going to give a quick summary of what happened today, and then we're going to get to as many questions as we can before I have to bounce and finish packing or at least call the airline and see what's happening. So let's do a quick summary of today's hearing. Oh, that was way too low. No. We need a superior swoopy doop. That's better. During today's status hearing before the Alec Murdaugh evidentiary hearing, the judge was very clear that this was going to be a tailored and concise hearing, but that a hearing is going to happen. And while she didn't officially rule like there's a hearing happening, it seems that there's a hearing happening because most of the hearing was spent on the procedure for that hearing, who will be called for that hearing and how. The judge determined that every deliberating juror will be subpoenaed for this hearing, and it will be inquired of them whether or not the clerk of court spoke to them, whether it was something substantive to the case, and whether it impacted their verdict. The defense was arguing very hard that the jurors, whether it impacted their verdict is not the relevant inquiry here, but could it have impacted their verdict? That is more speculative, but that is what the defense wanted to consider. The judge has said, no, we need to know if it impacted their verdict. So if the clerk of court spoke to the jurors, and if she said something like, don't believe anything Alec Murdaugh said, and the juror says, I discounted it, it wasn't relevant to me, I don't even know what she was on about, he's not going to get a new trial. It had to impact the decision that the jurors made, which is unlikely. All the jurors said when they were polled that that was their true and correct verdict. None of the jurors said in their interviews with SLED that they want to reconsider their verdict. So I think that sets the bar a little more difficult for Alec Murdaugh to get a new trial if in fact the jurors were spoken to by the clerk of court, which is still up for the evidentiary hearing. Every juror will be called. The defense wants the dismissed juror, the egg lady juror, to be questioned. The judge shut it down repeatedly that they could submit a proffer, but they are not going to be questioned and they are not going to offer a proffer in court. What that means with the proffer is that the defense can submit a written motion or a writing. It's not really a motion, it's a proffer saying, if this witness were called, this is what they would say, and the defense needs this as part of their case for XYZ reason, and then they will probably attach a affidavit of that juror to them. Remember, that juror, the egg lady juror, was dismissed not because of anything on Facebook, but because they were discussing the case with tenants of their building during the weekend. That's why that juror was dismissed. That juror is represented by Poot's good friend, Joe McCulloch, who we saw state that he represents one dismissed juror and one active juror. So that's what the proffer is going to entail. And it preserves the record of the defense saying, if I were allowed to call this witness, this is why, and this is the argument that I would have made. It preserves that for appeal. If the judge doesn't grant a motion for new trial, that ruling will be appealed, and it preserves their argument on the record without making that argument in a spoken way in court. So the judges said, go ahead and submit what you want in writing, but we are not calling them. We are calling the 12 jurors who deliberated and the clerk of court, and that is all they anticipate from the witnesses, or that's all the judge anticipates to be the witnesses. 1 day for the jurors and maybe 1 day for Ms. Hill, so maybe a 2-day hearing. The judges set aside 3 to 4 days for it if needed, and that'll be very interesting. We should have a written ruling from the judge, or at least a written minute order later today or tomorrow. I will be traveling, so I'll pull that up when I can, but there will be a hearing. It will only be the deliberating jurors. The judge will question the jurors. The defense needs to prove to the judge, because the defense bears the burden here, that there was a material statement made to the jurors, something more than lunch or parking or whatever, and that it impacted their verdict. That is a much more difficult burden to meet than it could have impacted their verdict, which is going to make it more difficult for Alec to get a new trial. His odds looked better this morning before this hearing started than it did at the end of it, and you could see that on his attorneys' faces, in my opinion, as we were going through this. This judge is going to be very clear about what the jurors are asked. You're not allowed to ask if something swayed their deliberation, and whether or not what the judge said impacted their verdict is going to be really the only question. So that's going to be very interesting. So we have a several day hearing coming up at the end of this month, and we will go through it. So there you go. That's what the judge has ruled. Very, very narrowly tailored hearing coming up. The judge definitely ruled more in line with what the state had been arguing than in line with what the defense had been arguing, and told them that at the beginning. So with all of that, I'm going to get to a few new questions, and we're going there. I totally thought you were getting a new trial. Now I'm thinking it's unlikely. Grass folks said, I totally thought we were getting a new trial. Now I'm thinking it's unlikely. The standard the judge applies matters the most, and it's going to be hard for the defense to overcome proving whether it changed these jurors' minds, whether if something was said, it changed their mind. Grass folk reminded me that the judge didn't rule about the timeliness either. That will come up, whether or not the timeliness here is an issue, whether the defense brought this in a timely fashion or not. Julie in the chat said they wanted a new judge. They sure did. And new judge they got. New judge they got. So we're going to hear those jurors' testimony. We will not see them on the stand, but we will hear their testimony. And that, I think, is a good thing. The reason these hearings are going to take so long is because both Poot and Creighton are verbose. What I appreciate, Emily, you stream for 4+ hours a day because you do not stop talking. Yes. I'm also a trial lawyer. Yes. This is not necessarily a bad thing. It just is. Creighton, I find more linear to follow. Poot is a bit more circular in the way he does things. It's just like around and around. But I feel like Poot tries to wear judges down till they just agree with him to get him to shut up. And Justice Toal is not having any of that at all. It's like, you need to stop. Stop right there. Thank you very much. So Justice Toal's not having any of it. I love the judge sass. I'm here for all of it. I'm ready for this hearing. I love being in live court with all of you. Let's get to questions, shall we? And for any of you that are new here, do the YouTube-y things, the likey, subscribe-y, all those things. You can find all of my streaming, the podcast and everything in the Lawnerd app. I'll be sharing where I'm doing behind the scenes things this week during my travels. So Lawnerd, I should have left that up longer. LawnerdApp.com is where you can find all that information. Free app for you to download. Keeps me in the loop with you. Set your notifications how you want, and then you know that you're getting a notification from us, even if you don't get one from any of the platforms you follow me on. Alec Murdaugh does not look happy. No, this was not going his way today. Feels like Poot is using word salads to confuse others and try to get what he wants. Don't think this judge is going to go for that. No, sure didn't. The non-egg juror may think the men are fine, but not like the ex. The ex may be salty about it. Yeah, it was such a random tangent, wasn't it? Allison said, question, if all Poot et al. Knew after trial was to talk to the jurors, but not actually what happened, then when they found out, brought the motion, does that still hurt their case? How so no matter yes or no? I think the question is, if they knew that this was an avenue to look at and then didn't have the information, how does that hurt? If they weren't diligent in going and finding that information, it can hurt them. If they knew something was up with the jury, they might argue we didn't know specifically what was up, and that might be somewhat persuasive if they said, look, the second we heard that, we went and started knocking on doors and none of the jurors were willing to talk to us. And I think that's their argument. What I've gathered from the defense's filings is that the defense said the jurors weren't willing to talk to them until the book came out. And then the jurors were willing to talk. So if they went and started knocking down doors of jurors like, hey, are you willing to talk to us? And they wouldn't talk to them, then they really didn't discover what happened until later. And it seems that a lot of those judges no, I got distracted. Sorry. Thank you for the flight updates in the chat. Amy, thank you. So I completely lost my train of thought. Apologies, chat. But I completely lost my train of thought. Apologies. I looked at the flight and totally knew. The judge and the jurors. So until the book came out, they're saying the jurors wouldn't speak to them. So it might be that some of the jurors were salty about what was said about them in Becky Hill's book. It might be just like Keefe D's book, just like Corey Richan's book. It might be that this book is the great undoing of all of the rest of it. But it seems that the defense has indicated that until Becky Hill's book came out, that the jurors wouldn't talk to them. So that's what that is. I'm catching up at how many degrees of separation until Poot gets to hearsay. He was at hearsay at the beginning. Shiraz said both true. One, Poot is a turd merchant. Be a minute. And two, Murdaugh deserves a new trial. Both things can be true. Both things can be true. Go ahead and end the poll, Miguelina. Sure. Again, Alex looks like, could we answer the judge or can I go back to my cell? He just had that look. He might have been tired of Poot's bloviating. I mean, he might have gotten a little, because what Alec Murdaugh can see very well in court that we can't see is the judge's face. We couldn't see how the judge was facially responding to Poot. Murdaugh can. Murdaugh was a trial lawyer. Murdaugh has been in a lot of courtrooms. Part of being a trial lawyer is being able to read people's face. I'm not always good at that with the ADHD. There's times I'm like, oh wait, are you getting bored while I'm speaking? I can feel you getting bored. But Murdaugh can see the judge's face and maybe was hoping his counsel would also read the judge's face. Question, as soon as Poot got loud, it tore my nerves up. Like, why is he yelling? Is it a theatrical stunt? Also, would like to know how you handle this kind of stuff. When opposing counsel is doing this in court, you just kind of sit there and are like, good for you, buddy. That's amusing. There was one point in court ages and ages and ages and ages ago where a defense attorney was like on one like that, and I started laughing. And it was so inappropriate. And I could not help myself. And the swiftness that the head whipped around to look at me and was like, could you not? And I was like, I actually can't. It's so ridiculous. I can't, it just erupted from my mouth. And the judge just kind of looked at me and I was like, I'm sorry. It's too much. I didn't always have the best control of my face. And that was the only time I actually audibly laughed out loud. I was not. It happens. But it was not in front of a jury. It was just at a court hearing, but it was ridiculous. So he was like, and she said the book would sell better if he was guilty. Like, what are you expecting, Poot, the audience to stand up and applaud? Sometimes I think the floor of the assembly and the floor of the court or the press conference get conflated a little bit. Tori, congratulations on 30 months. Music to my soul said, so let me get this straight, Emily. South Carolina has a mandatory retirement age for judges, but also brings judges out of retirement for some cases because they don't have enough judges. It seems that is the case. I think the legislature would have to change the law on the mandatory retirement age, and I don't know if they're going to do that. Question, is Poot ever presented to this awesome justice? It seems that they are friendly from everything I've seen, and yes, has appeared in front of this justice before. Question, do you think a retrial should be held elsewhere? I mean, we can cross that bridge of muddy water when we come to it, but I think that, I don't know if they would need to move it out of Colleton County. It would still be in South Carolina, but it might need to move out of that exact county. But how far out of the county is a whole thing. Because they are going to have problems finding jurors at some point. Judges 80, misogynistic lawyers, 0 fucks given. The judge definitely has been down this road before. This judge has noted Poot's arrogance. Yep. Lisa, you are welcome. Let's see. There is literally so much fuckery in this courtroom right now. Annoying. Do not remember any of this with Judge Newman. Oh, there was a lot of this with Judge Newman. There was a lot. Poot was Putin in front of Judge Newman like this during the motion hearings, more so than during the trial, because your demeanor at motion hearings and your demeanor at trial can sometimes be different in front of the jury. So this seems to be Poot's vibe. This is Poot's vibe. Like, talk in circles until somebody gives up. So Judge Toal is taking no prisoners. I'm here for the spicy judge. I'm here for the spice too. I didn't always like being on the receiving end of the spice. Sometimes that was uncomfortable. Occasionally it made me cry. Not in court. I waited till after when I got back to my office. I didn't always like being on the receiving end of the spice, but it's joyful to watch. So maybe that's mean. I'll talk to my therapist about it. Annoys me too when counsel disrespect the judge. They're a judge for a reason. This is true, but in some counties, judges are just elected and they might not be a judge for a reason other than people checked their names on a form. So, Stephen, I completely agree. I love the honey badger don't care vibes. His charm isn't getting him far and you can tell it's bothering him. Oh yes, this judge is not charmed at all by Poot. This judge seemed to be annoyed by the Putin and told the Putin to stop Putin around. There was no Poot scootin' Putin happening here in court. Question, how can Poot bring up Courthouse Becky's son? He has been charged but not prosecuted because he's bringing up everything. It doesn't mean it's persuasive. It's not, but he's going for the, Your Honor, where there's smoke, there's fire. And the judge is like, we need to do a hearing. So question, sounds like neither of the defense witnesses actually deliberated. Correct. Does that make a difference? Huge difference. Non-deliberating jurors are not going to talk. I think this morning, I thought it was more likely that he would potentially get a new trial. This afternoon, I think it is less likely. I think the defense has a pretty high hurdle here and they can't be feeling good about it. Lorraine said, this judge is like my mama, my mima. She on one and she ain't with shit. I love it. I absolutely love it. I hope that this is the last time the way I cackled. Just same the way I cackled. It was so good. It was so good. I'm still behind, but interesting morning. Yes, it was. I wonder if they missed their first judge yet. I hope Judge Newman watched this and also cackled. It was like, you get what you get and you don't get upset. Hey, Poot, you wanted a new judge. There you go, buddy. At this point, Poot wants Judge Newman back. Judge Newman's sass was even a little lower key, but I love the kind of southerny molasses accents. I am so delighted. 2 weeks, cigarette nicotine free. Hubby promised me a bougie coffee maker, wet brand, etc. as yours. Coffee is life, and coffee is life. I have a Jura, Jura. They're exceedingly bougie, but I love it. Though I have used some Keurigs, some of the bougie Keurigs that have the little like frother on the side when I stay at Airbnbs and stuff, and I love those as well. So it just depends if you want your beans ground fresh, which I love. There are lots of different levels of jura. I will tell you that if you go to like one of the bougie kind of home appliance stores, is that even what they're called? Like a Sur La Table or a Crate and Barrel or whatever, or Williams and Sonoma. Most of them that carry juras, you can go in and they will give you samples of coffee from the machines. So I would go and do a whole sample thing if you have a Sur La Table or a Williams and Sonoma near you and see where they carry them and go see what you think. So I like dumping the beans in the top and having it ground for each cup of coffee more than I want to use like pods and stuff like that. So that's just the way it worked for us. How much money can a person actually make from a self-published book? I have no idea. You know whose book is not self-published? Mandy Matney's. Mandy Matney's book, Blood on Their Hands, was published. Yes, she probably had deadlines that were not self-imposed. It is absolutely fantastic. She and Luna Shark Media have been so generous and gracious with their reporting and their time. So if you are curious about the deep dive from the reporter who I think brought all of this House of Cards down, go check out Mandy Matney's book. You can get it on Amazon. Here's why I say that. Mandy pulling at the threads of a settlement on the Satterfield case brought all of this to light, just like Edelson PC pulling on the threads of the Girardi case brought all of it to light. I think that was absolutely the catalyst for all of this starting to bubble up and people really starting to ask questions. The Satterfields had no idea there was a settlement until Mandy reported on it. It really did. It was just a local journalist following the rabbit hole all the way down, and I appreciate that so much. LawTube is so busy today. How will I do any work? I mean, there is a hearing today. There are a ton of criminal hearings today. It's like criminal court Super Tuesday. There are a ton of criminal. Is it actually also Super Tuesday? I don't know. It is like a ton of criminal cases today. There's a hearing later on the Scientology case. I don't think we'll get a ruling on it. There is so much going on today. Yes, there is. It is a busy day with hearings. We could only do the one. Miss Hill's lawyer, Mr. Lewis, is bae, just like Bates in Downton Abbey. If Becky conspired to remove egg juror as alleged, could that impact the verdict? It could, but I don't think this hearing is going to get to that. I don't think this hearing is going to uncover that because the judge isn't going into whether this action was taken. It's whether the jurors were spoken to, and that did it. Because here's the thing. The egg juror, and this is how I see the situation. Marie, I love this question because it gives me a good vehicle to try to explain this better. Becky Hill's bringing the Facebook post that wasn't a Facebook post, whatever, to the judge's attention is why the juror got questioned. But once the juror was questioned, the reason the juror was dismissed is because of the juror's own actions having conversations. It's very similar to what happened in the Depp Heard case with Gina Deuters. The defense brought up a Facebook or an Instagram post that wasn't even about the trial in Virginia, that was about the trial in London, but it brought the trial to a halt, and the judge inquired whether Gina had watched any of the trial, and Gina's response was, I had seen clips. That was why she was dismissed, not based on the posting. The posting just opened the door to ask the questions. If that juror, the egg juror, had not had conversations with people about the case, formed an opinion about the case, and talked about the case, they wouldn't have been removed because the Facebook post was disproven. So if they hadn't done anything to be removed, they wouldn't have been removed. So I don't think it will come up, because even though the way it was brought to the court's attention is in question and feels sus, that's not the reason they were removed from jury duty. They were removed because they talked to their neighbor. So that's the thing. And yeah, hopefully that makes sense. Mama Wolf says, if you did nothing wrong as a juror, there should be no reason to worry about answering questions from a judge. Mama Wolf, I respectfully disagree on this point, and I'll tell you why. With a high-profile case, the amount of internet fuckery that is going to fuck is a lot. And I can understand jurors being hesitant about having their entire lives delved into, potentially having their employers called and harassed, having people harass them on social media and dox them. I can understand the concern in a high-profile case that they are now being brought back in to be questioned. I completely get the nervousness there, especially as I'm going through Becky Hill's emails. I hate even talking about this, but as I'm going through Becky Hill's emails, there is identifying information of jurors contained in those emails that when the FOIA request was made public by media outlets were not redacted. And that bothers me. That bothers me a lot. It should have been redacted before it was made publicly available, I think, because that information's not needed to get the gist of what's going on in the emails. So as I've been going through those emails, I've been redacted it. Mujer Baracoa asked, all the jurors went on TV? No, only some of them, not all of them. Love the pauses for commentary. I figured since it wasn't a full day trial, we could pause. We would have time. Cleopatra 597, does Alec get to talk in this trial? Does he get to speak, say anything? No, he does not. There's nothing relevant that Alec has to say in this. Mr. Murdaugh doesn't know what the jurors did at deliberation. He wasn't there when the clerk of court spoke to the jurors. He has no relevant information to give in this, so there is nothing he needs to say. They are also hellbent on the egg lady. Does that mean nothing else is substantial? Tracy, I'm getting a little bit of that read too. Did I just hear the judge say the defense could not use impeachment evidence? The judge said that they would not rule on the impeachment evidence because they don't know what needs to come up. But you don't necessarily get to impeach a witness at a hearing like this until you see what they say and then have, it's kind of unknown. But no, the judge did not forestall that. What the judge said is that as a matter of course, the judge is not going to allow the alternate or remove jurors to testify because it's not relevant. It might become relevant. Hopefully I answered that one. Good to see you all. Chat, can he use his failure to get what he wants as the basis for appealing these proceedings? I mean, that's not the basis. But saying that the judge gave unfavorable rulings or is following the wrong law, that would be the basis. If this doesn't result in a new trial, will they appeal? Yes. Question, is it normal for a judge to rule on a hearing they will not be sitting in on? I'm not sure I understand the question, Tracy, because this judge is governing this ruling. Family account said, dude, I never want to sit on a jury. This is the concern with these high-profile cases with dragging all the jurors in to question them, is that jurors are going to have the same feeling. Jessica Parker, can the jurors decide not to do this? No, they'll be subpoenaed to court. And if they're subpoenaed, they have to show up or they're violating a court order. I think the jurors at this point probably want to defend their verdict. I would imagine. That would be my guess. If I'm a juror and I'm seeing all of this nonsense swirling around and I'm like, I knew that motherfucker was guilty. That's why I voted guilty. If this is how I was feeling as a juror, I'd be like, bring me to court. Bring me to court. I sat there for 6 fucking weeks and y'all are going to talk about what we did. Bring me to court. I have a thing or two to say. So that's how I would feel. Everybody might not feel that way. Newman's oh boy comment at Becky questioning juror without his presence, said juror was still on the jury. That was the egg lady juror, if I'm remembering properly. And Judge Newman said, I don't like her questioning that juror without me. And I agree. And that should be inquired into. Love you through the day. Pray for you at night. Thank you, Babs. Prayers for safe travels. It's getting very sunny, so hopefully it will, even though it's cold AF, hopefully roads will be passable the way I'm going. I think they've had time to clear the highways, so it shouldn't be a problem. Poot really tried. The man deserves a retirement. We forgot this man is 74. Thank you, Emily, for your live streams. He's chosen to continue going. So, love the Law Nerd community. Same. If a new trial, will they find unbiased jurors? Finding jurors that haven't heard about this case is going to be hard, but I thought that the first time because the community was so small and Murdaugh was such a big figure, and they did. So it'll be hard, but I think they can. J. Michael RN, good to see you. If you were Courthouse Becky's attorney, would you advise her to exercise her right against self-incrimination? That is a question-by-question basis. And I don't know enough to advise somebody. So it is a question-by-question basis. If it's needed, you have to advise someone to take it. If it is appropriate and needed, you have to tell them to protect themselves from potential criminal prosecution and not worry about the court of public opinion and worry more about potential prosecution, especially if the investigations that we keep hearing are underway are in fact underway. If she's being investigated for the ethics complaints and other things, she might need to. Brandy said, I'm way behind, so forgive me if this has been asked. If Alex gets a new trial, can they use previous trial to impeach witnesses? Yes, they can. What happened at the first trial comes up at the second trial. It's why in Depp v. Heard you saw them flipping through so many books of things. Vicky, can Becky go to jail? I mean, we don't know what happened here yet, so it's premature to answer that question. But it seems that there are multiple investigations going on. Crazy Quilter said, I lived in Savannah, in the Savannah area when the boat accident happened and death of a family. It doesn't surprise me that this hearing is happening. Picture me shaking my head. The boat crash was wild. Do you think Becky's watching your stream now? Hopefully not mine and just watching the court hearing. Question, by Alex's reaction, do you think he knows it's bad? Yes. Alec, I mean, though disbarred, is still a lawyer. He can read the room sometimes. How can Creighton be a witness? Everyone's a witness. Everyone's a witness. Garden Lover says, how does that work? Will her attorney stand up and say, I advise my client to plead the fifth if a question needs it? It depends on this particular court's procedure, but it generally comes from the individual saying, I want to plead the fifth, and the court saying, okay, or the court saying, you just need to tell me your name. You can't plead the fifth. Generally, the attorney does not stand up and say, I advise my client, but that goes jurisdiction by jurisdiction, and it goes question by question. Lori said, chat, you can use your Air Mile rewards to get a Jura coffee machine. That is a great tip. I love my miles. Let's see. Justice was clear. This hearing is not a trial of Becky. Super duper crystal clear. Co-author has donated his part less than $3,000 in total. Salty Beach Girl Lori. I don't know if that's his entire proceeds of the book or if that's his proceeds of the book since this was discovered. I'm still unclear. Question, are jurors paying for their own counsel? Yes. JJ with the dog, they are. Unless Eric Bland has, offered to represent them pro bono, meaning for free, which is also a possibility, but no one else is paying for them. Blanca said, so happy to have found you. Well, I'm so happy you're here. Thank you for everything. You're welcome. Christy said, read the room. They're trying. Can this appeal be dropped by the defense or are they strapped in for the ride? The defense is the defense. They can stop at any time. I tell my children this all the time. I'm like, you can stop arguing with me at any moment. You initiated this. They can choose to stop. I think that's going to be difficult at this point. I think they knew that they were in it for the long haul, but I also think these attorneys are going to fight every single tooth and nail for Alec, and that is partly their job. So, Jag said he just can't accept what part of no do you not understand. He's going to keep going. He's going to keep going. And with all of that, y'all, I need to go finish packing. Lana, will they have to get jurors from out of state? That is an extreme remedy that probably won't happen. Some states won't even allow for it. You need jurors within your state. They can move around to different parts of the state, but you need jurors in your state. You will always find people that don't pay attention to this stuff. There's lots of us that pay attention to it, but you will always find people who have shit to do and have lives and don't do this. Who's paying Alec Murdaugh's team now? Who knows? His team has been complaining that they're not getting paid, but I have no idea who's doing it. So with that, Lawnards, it's great to see you. Thank you for being here. Follow me along on the Lawnard app and on social media. I am most active here on YouTube and on Instagram, so you can follow me there. I will be traveling around, so I will not be streaming on Thursday unless something wild happens. If I put up shorts or anything like that, I'll let you know in the Lawnard app, and they will be on the Quick Bits channel. You guys are the best community on the internet. Thank you for making this the best place to watch live trial coverage. I am going to travel briefly, and then we're strapping in for this hearing on January 29th. There are lots of hearings to come. Hopefully nothing pops off while I'm flying. Wish me luck that it just all goes smoothly. And then I will keep you in the loop for everything that goes down tomorrow and for the rest of the week. So, Crystal said, so I have no life. No, this is your life now. It's a very good life. We get to talk court and sass and drama. And they won't have any rogue guns in the courtroom this time. So we won't have Poot waving firearms around in the courtroom. So that at least will make me more comfortable. So hopefully the rest of the day doesn't pop off, but you never know. Lawnards, you're the best. Don't forget to do the YouTube things, and I will see you in the next one. Don't forget, podcast premieres tomorrow at 11 a.m. Central. You are not going to want to miss it. If you have the audio apps, you will get it dropped at 5 a.m. to you, covering all the litigation going on in the Leah Remini Scientology case. There was a ton of litigation happening. Some of that's being heard today, but I don't think we'll have a ruling on it. So you want to get up to speed on that case. It is BANANAS. See you next time.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for LawNerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.